Good morning, everybody. It's a Wednesday. Welcome to Courtroom Files Live, episode number 179. I can't believe I've done this 178 other times with you guys. It's so good to have you here. So we're going to start with Judge McNally, where shortly, I believe, we will see the probably not so triumphant return of Horderman, but let's see what's going on.
25B149141. Your name, sir?
Anthony, anyone with you?
Good morning. You're charged with unsafe load. You have the right to an attorney. Would you like one?
No.
I'll go ahead and arraign you and then I'll let you go talk to the prosecutor, okay? It is alleged that on October 29 of 25 that you did operate a motor vehicle on I-75 northbound near Vreeland in the township of Brownstown at 8:59 p.m. They think you had an unsafe or improper load that is misdemeanor, punishable by up to $500 fines, 90 days jail, costs for all of those penalties. Do you understand that?
Yes.
Did you sign an advice of rights?
Yes.
Did you read it and understand it?
Yes.
You plead guilty, you'll be giving up all those rights, and we're not going to have a trial. You understand that? All right. You still wish to waive your right to a lawyer?
Yes.
I'm entering a not guilty plea. I'll give you a personal bond. You don't have to post any money. $500 personal bond, but you'll owe the people of Brownstown $500. If you violate any of these terms, you cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You understand all that?
Yes.
All right. Do you have any questions? Go out in the hallway. We'll take it to the township attorney and she will call you in.
Okay.
Thank you. Either way, you're coming back in front of me, okay?
Okay.
Do I dare call this case, Mr. Boyd? Robert Thomas Boyd, 25B82557. Calling the city attorney, please.
Ladies and gentlemen, this is
Township
Horderman.
attorney.
Enjoy.
Morning, Tom.
How you doing, Mr. Boyd?
Pretty good.
Your name?
Robert Thomas Boyd.
Okay, so I'll give you a lawyer if you want one. This,
Thank you.
you gave your right to a lawyer?
Yes.
You're here for a review hearing. Please tell me you did something with the property.
Oh, yes, sir. I got a big trailer full of stuff out of there.
Did you?
Yeah. A big trailer. 6.5 feet high, 8 feet long, wide, and 8 feet long.
Did you get everything out of there?
Not everything.
No.
He's supposed to bring me another trailer when he dumps out.
I know, but did they take the whatever debris you put in the trailer and remove it?
The guy's taking it out here today.
Good morning, Your Honor. Caitlin Boyd, part of Brownstown Township.
Ah, so I said, do I dare call this case? What have they done? Go ahead.
Sure. Ordinance Enforcement Officer Rob Harris went by the property yesterday. He advised that the dumpster was full. The garage, trailers, boat, cars, junk, and debris were still evident from the street. He did go into Township Hall and obtained a demolition permit application. However, he's never filed that, nor has he gotten a demolition permit.
Well, I don't need it, Your Honor, until I get ready to demolish it. I'm pulling everything out of that garage, the cabinets and all that stuff. So when I demolish it, it'll come down easy. So I didn't know if there was a time limit on the demolition permit. Is it? You don't know? Oh, she don't know either. He's supposed to bring me back another trailer today.
You gotta move a little quicker here.
Well, that's a lot of work.
We've been talking about this. You were issued citations quite some time ago.
Yeah.
And this citation was issued in April. This is November. How many notices did they send prior to that again? How far back does this whole issue go?
The property itself is, the ordinance violations have occurred since 2001.
Okay. So last I looked at the calendar, it's 25, right? I wish it was 2001, but it's not. Please. I don't want to have to send you to jail again.
I don't wanna go. I got too much work to do on that garage.
I know, but you gotta move faster. Please?
Getting help would help a lot, but it's hard to do.
If I may, Your Honor, I did, last time we were here, a Good Samaritan knocked on my door and advised that they were there because they wanted to help Mr. Boyd. My understanding, she received his phone number from one of our hearings. She tried to make contact with him multiple times, left multiple voice messages, and he never returned her call. She is interested in finding help. He just needs to connect with her.
With
Her name's Adrian. She left you a couple voicemails.
she did,
She did.
she wants to help me.
She does.
She's gonna let that heavy stuff.
She has a whole bunch of people that want to help you to stay out of jail.
See,
I didn't get them.
Mr. Boyd, listen to me. I have felt awful sending you to jail, but I have a job to do here. And I'm going to do my job. I don't know what else to tell you, sir. You gotta move. You gotta get this stuff out of there once and for all, for your safety too. All right, here's what I'm doing. I mean, I don't think she would tell the prosecutor she called if she didn't call. Probation is extended. I'm extending your probation. Probation's extended but this doesn't mean you have this long to do this. Do you understand?
Yes, I do.
To July 30 of 26. No probation fees. Lisa, please give me another review hearing date sometime in early July.
I'm looking. Hang on one second.
Take your time. I'm going to set another
July 1st at 9 o'clock.
at 9 o'clock. Now I'm going to give you another review hearing date to come back in front of me, but I want all this stuff going. Listen to your voicemail. Call the lady if she's willing to help. Or your sons, I don't care who you get. Sir,
If Mr. Boyd wants to
Yeah.
be in the conference room, I'd be happy to give her.
sure.
Okay.
Now listen, I don't care who does it. You know, ultimately it's your responsibility, but I can't give you much more time. And I know you're going to start telling me the weather, but you should have done it when I told you to do this. Lisa, give me something the second or third week of July or January, please.
January 14th at 8:30.
That's your new review hearing date. So the other one, the July date, is to dismiss the case if you're compliant.
Okay.
This is going to be another review hearing date, January 14th. You got to get going. You got to call that guy, have him empty that, give you another dumps, whatever you got to do.
I understand. I would just like to reiterate that I think our biggest concern is still the dangerous zone.
Of course it
Garage.
is. It needs to be,
Everything on.
Mr. Boyd, come on, man. You're such a likable guy, but you're killing me. You know that? You're going to make me do something again that I don't want to do. I already had to do something twice that I didn't want to do. Come on, please. Don't do this. Get this stuff, get that all taken care of by January and we all can all go on. I'll buy you lunch. You and I and the prosecutor and the building official go out. I'll buy lunch. Take care of it, please. January 14th. Thank you. Have a good day.
Thanks.
Good morning once again, everybody. Welcome to the Courtroom Files Live, where apparently judges are now giving out lunches if people would just clean up their yard. Oh, Hoarder Man never ceases to amaze and amuse. I have made a note. January 14th. We'll pass that along to Ashley so she can make a note as she is the official keeper of dates and times here at TCF. Let's go over to Judge Mindy Glazer in Miami-Dade. I need to step out of the studio for a few minutes, so I'm going to leave you guys here, and I'll be right back with you as soon as I can. Enjoy.
Bien, señor, tiene orden de detención por parte de la entidad migratoria, por tanto no se le puede otorgar el programa antidrogas. Que tenga buen día. Fianza $1,500.
Right, next, we have Michael Redding, page 3. Good morning, sir. You were arrested for 3 cases, selling cocaine. We'll go case by case. I will appoint the public defender's office for you. You are also going to be ordered to stay away from the Jiffy Food Store at 16475 Northeast 15th Avenue in Miami, Florida. You're not allowed to go to that location. You must stay away from there. And so we're going to start with the case ending in 25065. There's probable cause. It's 2 counts for it's 2 counts sale of cocaine within 1,000 feet of a school and a church. So I'll find probable cause and split them. I guess I'll do $5,000 each count. The next case, F25-25066. It's from November 12th. You're charged with sale of cocaine within 1,000 feet of a school and a church. So there's probable cause for the charges. 5,000 count 1, $5,000 count 2 is the bond. And the last case, F25-25064, is from yesterday. You're charged with 2 counts of sale of cocaine within 1,000 feet of a school, 1 count of possession with intent to sell cocaine within 1,000 feet of a church or convenience store, 2 counts of possession with intent to sell cocaine within 1,000 feet of a school, and sale of cocaine within 1,000 feet of a church. So let me look at this case. So it's a little overcharged.
I only see one alleged sale,
It's one
And then
sale.
there's the stash.
but they already discussed the sale that he was arrested.
No, the other sales were for the
Oh, you're right. That was the other case we already did.
it's just one sale in this case. I don't know why they charge so many.
I think because of the stash and the different locations. No objection to reducing the bond.
What do you want me to set it on 1 and 2 and that's it? Can we do 3 counts? How many counts you want me to set?
Two's
Dollar
okay.
there. 5,000 count 1. A dollar count 2. $5,000 count 3. And then counts 4 through 6 will be $1 each. All right, thank you. Next, Carlos Clavijo.
Bond out.
Thank you, bond out. Harad Talbert.
These are added charges, corrections.
Yes, these are added charges.
Page 4 more quick cases.
Judge, can we pass him for one moment?
Yeah. Our next, Angel Santana, page 5. Good morning, sir. You were arrested for
Spanish, please.
Spanish, unlawful possession of a stolen credit or debit card and fraudulent use of a credit card.
Tenencia ilícita de tarjeta de débito o crédito y también uso ilícito de tarjeta de crédito son las acusaciones en su contra.
I will appoint the public defender's office for you.
Le asigno a la Defensoría Pública para que le represente.
You're also out on felony bond. I don't know if there should be a hold. Yeah, there should hold for F25-15041.
También tenemos orden de detención, ya que se encuentra usted bajo fianza en un caso anterior, F25-15041, queda detenido.
All right, so good probable cause. I'm setting up on $2,500, count 1, $500, count 2.
Existe base legal para los cargos. Primer cargo, fianza $2,500. Segundo cargo,
Your judge
$500. El día de
Entonces-
mañana estará ante su juez. Sorry, Your
Thanks,
Honor.
Dick.
Que tenga buen día.
What? Corrections, what did he say?
Never mind, I'm sorry, Your Honor.
No worries. Does she have a case here? Can we get it? Thank you. Corrections, I need to call a case at a turn for somebody in court. Page 7. Gerald Russell. Thank you. So I need Gerald Russell on page 7. I guess the victim's in court. Are you the victim, ma'am? You can come up to the podium, please.
Judge,
What
which
page?
case? Which case did?
Page 7, Gerald Russell. Good morning, Mr. Russell. You were arrested for strong arm robbery and false imprisonment. It's a case from November 10th of 2025. Can you afford to hire an attorney, sir?
No.
I will appoint the public defender's office for you. Ma'am, can you raise your right hand and be sworn, please? Do you swear or affirm the testimony you are going to give in this proceeding will be the truth? If so, state I do.
I do.
Thank you. You can put your hand down. Please tell me your name.
My name is Maggie Beatty.
Miss Beatty, are you afraid of Mr. Russell?
No, ma'am.
Do you want the court to order him to stay away from you?
No, ma'am.
Has anybody forced you or threatened you to come to court today to make this statement?
No, ma'am.
Okay, thank you. State any questions?
No questions, but I wanted to put on the record that the defendant has priors out of county. It looks like it was an attempted murder where he served a prison sentence and there was a parole discharge from January of this year. He's also got a New York driver's license.
All right. Mrs. Corey, I'm sorry. Do you have any questions for the victim?
No, Judge, thank
All right, sir, I'm entering a modified stay away order from the alleged victim, Maggie Beatty. You are allowed to have contact with the alleged victim. You are prohibited from being physically threatening or violent towards her in any manner whatsoever. So only friendly, nonviolent contact is permitted. Do you understand that, sir?
Yes, ma'am.
Also, do not engage in any criminal activity. Do not use or possess illegal drugs. And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the modified stay away order?
Yes.
Okay, thank you. All right, is his baby too?
Yes.
Oh, how old's the baby?
2 months.
2 months old. All right, are you living together still?
Yes, ma'am.
All right. I'll give him pre-trial.
Judge, has he been in Miami a year?
How long have you been in Miami for, sir?
Yeah, I've been in Miami for more than a year.
More than a year? More than a year. Is that what they told you to say over there?
But he still has that New York driver's license.
Why do you have a
and-
New York driver's license? You're supposed to change it within 30 days of moving here.
I didn't know. I'm,
He
lear-
says-
I'm learning that. I'm learning everything as I grow.
Oh, okay.
I
You
didn't.
got a cute baby. What a cute little baby. He's sweet. Is it he or she?
A boy.
A boy's cute. You better shape up. You want to be there for your child and not in prison somewhere for
Yeah.
fighting with mom. Retrial services alternate bond, $2,500 count one and $1,000 count two. All right.
Thank you.
Good luck to you both. Have a
Thank
nice day. Okay, next case, Mark Williams.
On the pretrial order for
Oh, pretrial order,
that they can live together.
look at that there.
Thank you.
Thank you. Ma'am, if you wait a minute, we'll give you a copy of the modified stay waiver. Okay, thank you. You're free to go.
We have,
Mark Williams.
we have Mr. Talbert now.
Who?
Mr. Talbert.
Talbert. Okay. Bring in Mr. Talbert. He's on page 4. Good morning, Mr. Talbert. So you're here because you got a bunch of theft cases, 4 more cases. I'll appoint the public defender's office for you in all the cases. They're all charged with retail theft, prior conviction. I don't know if that's right. Starting with F25-25068. That is from March 19th of 2025. It charges retail theft with a prior conviction. So it's alleged he took concealed items and exit the store with a rolling suitcase, $350. It says he's been arrested. It doesn't show he has conviction, so it's just probable cause for petty theft.
Right, it says arrested and convicted for the following petty theft
Oh.
incidents.
You're right, he has a prior conviction. You are ordered to stay away from the TJ Maxx store at 1149 5th Street, Miami Beach, Florida. You're allowed to go to that store and you must stay away from there. Do you understand?
Yes.
Okay. So that bond, I don't know what he's seeking in terms of the bond. You want 15?
It's standard because of all of his open cases as well as the recent conviction for multiple thefts.
Okay, I'll set the bond on this case at $1,500. Next, F25-25055. This is retail theft with a prior conviction from TJ Maxx in North Miami. Here it mentions prior convictions. He took merchandise, including the luggage, $600. So this is from March 5th. I'll set that bond at $1,500. Stay away from the TJ Maxx at 12163 Biscayne Boulevard in Miami. It's actually North Miami, Florida. You're not allowed to go there. You must stay away from it. Then there's F25-25054, another retail theft. This is from TJ Maxx in North Miami. He's taking luggage with merchandise inside. It's can I have that back? I'm sorry, I gotta fix something. There's probable cause for retail theft. The value of the merchandise was $955.71. So the bond here is $2,500. Then there's F25-25053. This is from November 10th. You're charged of petty theft for more convictions. This is from the Marches in South Beach. So he's stealing items inside a rolling suitcase. There's probable cause for petty theft for more convictions. Your bond is $2,500. Stay away from Marshalls at 723 Lincoln Lane in Miami Beach, Florida. All right, that's it. Have a nice day. Next is Mark Williams, page 5. Good morning, sir. You were arrested in this case for organized scheme to defraud and grand theft. Can you afford to hire a private lawyer?
I'm gonna try if I can get back to my job.
Do you own your home?
No, I live with my mom, but I've been working for this one bank for over 7 or 8 years.
Do you have any money in the bank that you can use to hire a private lawyer?
Yes, I'm gonna try to, ma'am.
All right. Do you want to proceed now without a lawyer? Or do you want me to, you may be, I don't know if you're eligible for the public defender, how much you have saved up in the bank?
I've been working for a while. I got enough to borrow down and stuff, but I'm gonna go with a public defender for now. Then I'll eventually transfer over to a lawyer.
All right. How much you have saved in the bank?
Number 7.
Yes, I have. I think probably about 2,000 or 3,000.
Okay, I will appoint the public defender's office for you.
So the
this?
defendant's got priors out of county. I'll show the court.
What's
His-
this for? He's getting dental work done?
Yeah.
All right.
So he's got prison sentences from Marion County. He's been in prison a few times. The most recent release was in 2019.
Okay, let me. So this is similar to the case we saw yesterday. He makes an appointment for dental work, says his brother's gonna make the payments. And he sends them money, he sends payments, wire transfers. And then he said he accidentally made a payment. Well, they send it back to him on Zelle. She got suspicious and realized 3 payments and questions were made from her own business money market account to her business checking account. There's probable cause for the charge of organized scheme to defraud and grand theft. You are ordered to stay away from the Miami Cosmetic Smile Center at 9724 Southwest 40th Street in Miami, Florida. You're not allowed to go to that location. You must stay away from there. Do you understand, sir?
Yes, ma'am. Yes, ma'am.
All right. Count 1, organized scheme to defraud, is $1,500. Count 2, grand theft, is $1,000. Have a nice day. Next case is Carrick Johnson. Page 5. Good morning, Mr. Johnson. You were arrested for strong arm robbery. I will appoint the public defender's office for you. Stole from the victim who's in a wheelchair. Okay, and the victim's struggling to keep his phone. He dragged the victim out of the wheelchair before he took his phone and fled. All right. You are ordered to stay away from the alleged victim, whose initials are CV. No contact with that alleged victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. You must stay at least 500 feet away from the victim, his home, school, and place of employment at all times. I'm setting a bond, $7,500. Good day, sir.
All right, I'm back. Apologies for a few minute absence there. Some other things we had to take care of here at the bunker. Let's change it up a little bit. Let's stay in Florida, but we'll make our normal morning visit with Wade Mercer.
New allegations. Ms. Barfoot, I'm going to ask you first to listen to Mr. Atkinson, and we're going to see what his position is, and we'll go from there. Mr. Atkinson?
Your Honor, I reviewed the video. It appears that there was, she was in her driveway, was walking. That's what I saw. I never seen her get closer, and I don't know the distance because of the video, but it didn't appear that there was any issue. It just, she was in her driveway and either said, I know you're filming me, or I know they're filming me. I believe her mother was in the yard with her, and I'm not sure. I don't know who it was directed at, but definitely was not close to. It wasn't like in the victim's face. So I reviewed it, Judge, and that's all I saw. And there may have been other stuff I missed or couldn't hear properly, but that's the only thing I've seen. And you know, if it is a violation of law, I think it's not egregious. I don't really know how you and you know monitor this based on the fact they're next door neighbors. And I know the case law, like I said yesterday, was somewhat in favor of trying to work it out with neighbors, but she did say something too, and it was talking about filming. So, Judge, I would ask, based on the non-egregious nature of what happened, that you just reinstate her bond on the new charge. I mean, the old charge. I'm sorry, Judge.
Give me the either of you have the case number?
Yes, Your Honor. The new case is 25561MM.
So, Mr. Mitchell, before I hear from you, let me refresh my memory of what the complaint alleges, because I think Mr. Atkinson's summary is correct. I just want to look and see what the complaint alleges. It was not, it arguably, I think that I found probable cause that was directed to the alleged victim, but more said towards her in her presence, intended to be heard by her, as opposed to going up and talking to her. And certainly it wasn't threatening. What the complaint says, alleges, oh wow, that's really alleges, oh wow, that's really small print. Too old to read that. What the complaint says is at 12:41 on video, she said, "You're not going to believe this. Never mind, I do believe. Every time I go outside, oh, shit, it's ridiculous." And then at 13:13, she said, "You're not going to believe this. Never mind, I do believe. Never mind, I do believe it. It's ridiculous. I know you're recording me. That's okay. I'm not doing anything wrong." So my question for law enforcement before I signed the warrant was she on the phone, or was she talking to someone else? And law enforcement's response was to send me a video that I didn't ask for, but watch 15 seconds of the video clip, which I did watch. And there's no one else on the video. Now, Mr. Atkinson may be correct. Maybe someone else off video. I have no idea, but it does not appear she's holding a phone. So that was the basis for me finding probable cause for the new crime and signing the arrest warrant. But as I mentioned yesterday, due to the lack of egregious nature, I was hesitant to revoke her bond. Mr. Mitchell, what's your position?
Your Honor, I did want to say that I also reviewed the video yesterday, and there was also an additional part, I guess, in response to Mr. Atkinson saying that he believes that this was directed at her mother. I listened to the video also, and I heard Ms. Barfoot say at one point, "stupid idiot," also. So I don't know if she was directing that at her mother.
So what are you asking me to do? Are you asking me, let's start with the bond issue. Now that you've had a chance, I'm thinking your email that you sent to me and Mr. Atkinson, you said you had spoken with the alleged victim.
Yes.
So are you asking me to revoke the bond or not?
If she does not want to accept the offer for 1-year probation in case number 25464MM with the agreement that we dismiss this new case, then yes, I am asking that we revoke the bond in that case.
So Mr. Atkinson, there's no plea agreement reached. Is that correct, sir?
That's correct at this point in time, Judge. Judge, may I correct one thing if I misspoke?
Sure. Sure.
All I said was, and if I misspoke, I apologize. I believe her mother was in the yard with her. I don't know who it was directed at. I just know her mother was in the yard with her.
I may have misspoke. My apologies also.
So what's in the complaint that's most concerning is she has an injunction. She's been to court. She's been accused of violating an injunction. She's ordered again, no contact. And then allegedly on video, she supposedly says, I know you're recording me. That's okay. I'm not doing anything wrong. That portion would appear to be directed to the alleged victim. Now, the rest of it, you're not going to believe this. Never mind. I do believe it every time. It's ridiculous. That could she be talking to herself or talking to someone else.
Yeah.
But I know you're recording me seems to be directed to the alleged victim. And that's, if that happened, that's certainly probable cause for violation of injunction. So my question, Mr. Mitchell, is did you get into the circumstances surrounding the recording? Is this like a ring system that's being recorded on? Is the alleged victim got a phone in her hand? Is this a 24-hour recording? Where does the recording come from?
It looks like it comes from her cell phone by the looks of it. Or
when the alleged victim goes outside, she has a cell phone recording every time she goes outside? I don't understand.
That's the way I see it.
Yes, sir.
Judge, what I understood happened is my client was outside working in her garden. And then the victim came out to, I think, put up a wind chime or something like that and had her phone recording. So after my client already went outside.
All right. Don't say anything. Your attorney don't want you to say anything to hurt yourself. Mr. Mitchell, anything else from the state?
No, Your Honor.
Mr. Axon, anything?
No, sir, Judge.
Okay, I'm not comfortable holding someone in jail with no bond for that statement. Okay, I just don't know that that's something I'm comfortable doing, ma'am. What I am going to do is I'm going to stress to you the following. There is an active injunction, and I would suggest to you say absolutely nothing to this person. If she's outside, don't say anything towards her. You talk to whoever you want other than her, but don't say anything to her, and don't say anything. I wouldn't even say anything about her because she may interpret that as being directed to her. You want to talk to your mother or anybody else, that's your right. But you certainly can't say, and this is what you're accused of. I'm not saying you did this. I'm saying this is what you're accused of saying is something directed to her. I know you're recording me. That's okay. So the reason I'm going to give you the opportunity to post bond is there was no threat of violence. You spent a couple of days in jail, and I just need you to understand no contact, and the injunction issued by whatever judge issued it, it wasn't me, means no contact, nothing at all directed to her in any way. If it happens again, I will have no conclusion but to reach, the only thing I can do is assume it was intentional. I'm kind of giving you the benefit of the doubt in this situation for the reasons I already said. But nothing at all that can be interpreted. And she's got the right to record you. You've got the right to record her in public. So that's strange, but it is what it is. It's unique, I should say.
My husband is building a fence, privacy fence.
Let me see if your attorney has any other suggestions, because Mr. Axon wants to keep you out of trouble, probably as bad as I do. Mr. Axon, any other questions or instructions for your client?
No, Judge, I would ask and instruct her to come to my office as soon as if she posts a bond, come to my office. We will go through it in detail, Miss Barfoot, one more time.
Thank you.
And we'll talk about the fence. And if there's a fence going up, Judge, that may solve a lot of problems. So
it's already $700 in it already.
Fences make good neighbors.
That's right.
And
all right, let me see if Mr. Mitchell has anything.
not at this time, Your Honor.
As far as court date,
I think we can set her for the December case management docket.
Mr. Axon, is it your intent to represent her on both charges, sir?
Yes, sir, Judge. We're going to do that.
Okay, so she's probably already set for a case management docket on the first case. So let's add the second case to that same date, whatever that is. And Mr. Axon will get a notice. You'll get a notice. So Ms. Barfoot, make sure you follow Mr. Atkinson's instructions. You have the bond I set yesterday in the new case. I'm not revoking your bond, as I've explained. You post the bond on the new case, you'll be released. Do you have any questions, ma'am?
No, sir. Thank you very much, Your Honor.
Ms. Barfoot, come to my office as soon as you're released, okay? Please, okay?
Yes, sir.
Right.
Yes, sir.
Thank you.
I'll be there.
Thank
you all.
Appreciate it.
All right, so we do have friends or family here on at least one case. That's Jan Pravat. So let me see Ms. Pravat next, please. Ms. Pravat, good morning. Ms. Pravat, my notes. Your son and your daughter are both in the courtroom. Ms. Pravat, you've been accused of 3 charges. Discharging a firearm over an occupied dwelling. What that statute is titled is discharging a firearm in public or on residential property. There is one little subsection that says over an occupied dwelling. I don't know if there's probable cause she discharged a firearm over a dwelling. She allegedly shot in the air. There's certainly probable cause that she discharged a firearm in public or residential property, which is what the statute's called. The second charge is improper exhibition of a firearm. That's another first-degree misdemeanor. The third charge is use of a firearm while under the influence of alcohol. So there's probable cause for 3 charges, all of which are misdemeanors. I'm going to appoint the public defender's officer to represent you. I'm going to ask that you listen to Mr. McDaniel, your attorney, and then we'll listen to the state. Mr. McDaniel.
Your Honor, we just asked for a reasonable release option, take into account that neighbors are having problems. You know, I don't think the officers put everything in the complaint. I don't know if they put in there that she was on her front porch when she did this. You know, they clearly do not like each other and are arguing and bickering, and the neighbor comes over in fighting mode to her residence with someone else with her to essentially beat her butt. You know,
Is that an allegation in the complaint?
It's not. They didn't put any of that in the complaint. I don't think any of that was in the complaint that it was happened on her porch. You know what I mean?
The complaint says the neighbor was in her vehicle.
What's that now?
The neighbor's version is she was in her vehicle when it happened.
Okay, so
that's the neighbor's version. I don't know.
I was thinking. Yeah, she told me it was. You know,
and it may be.
Yeah.
It may.
No, sir, I wasn't on the. I wasn't in my vehicle.
Don't talk, ma'am. I'm telling you a story. Okay?
No, I'm trying. Let me clarify. The complaint says the neighbor was in the neighbor's vehicle, not Ms. Pravat was in the vehicle. It doesn't say where Ms. Pravat was at, but go ahead, please.
Yeah, and that, you know, that's, you know, keep that in mind, Your Honor, that you know, she's alleging that and she has witness there also. She tells me that she was, you know, coming back to her property to the front porch and has done this before in the past in fighting modes, and just take that into consideration. And also, you know, I know the officer puts in there, and I just happen to know my observations this morning, and I know people that have really high blood pressure and other issues. Her eyes are bloodshot red right now. I'm not saying the officer is mistakenly about the alcohol. I don't even know, but I just know her eyes are bloodshot red right now. And I don't know if that has to do with high blood pressure and other issues, you know, instead of alcohol, but she was just driving. I kind of question when she was on alcohol.
Okay. Thank you. Mr. Mitchell.
We're in agreement to a reasonable bond under the circumstances and treating the discharging firearm as in public charge instead of over an occupied dwelling.
Ms. Pravat, the criminal history I've got shows no prior criminal history. Is that accurate, ma'am?
Yes, ma'am. I've never been in trouble.
Ms. Pravat, I'm not going to give you conditional release because the allegations of a firearm are very concerning, but I'm going to set you a lower bond than I might normally set because you have no prior criminal history and because these 3 charges are all very similar to each other. The officer's chosen to charge 3 charges, and I think there's probable cause for 3 charges, but the state certainly may decide to charge 1 or 2 or all 3. That'll be their call.
I forgot one other thing. We would also include a condition of no possession of firearms and no possession or consumption of alcohol. You were probably going to do that, but I just want to put that on record.
Thank you. So, Ms. Pravat, your bond's going to be $2,500 on the first charge, discharging a firearm in public, and $1,000 on the other 2 charges. Your total bond is $4,500 cash or surety. You have a condition that you not possess any firearms while this case is pending. You can't have access to firearms. You also cannot possess or consume alcoholic beverages because there is an allegation. Other than bloodshot eyes, there's other indications the officer saw that alcohol, that your abilities were impaired, which is an element of one of the charges. So you cannot possess or consume alcohol. You can have no contact with Ms. Nichols, the alleged victim. What that means is this. Her bond is $4,500 cash or surety. Cash or surety means you don't have to come up with all the money. She doesn't have to come up with all the money, and she can go through a bondsman. If you go through a bondsman, and if they charge you the normal 10%, it would cost you $450 to get out of jail. If you pay all $4,500, you'll get it all back. If you go through a bondsman, what they charge you is their fee. And that 10% is sometimes negotiated by a bondsman. So those are the conditions. She has no firearms, no alcohol, no contact with this person at all. If she sees her walking across the street, she ignores her. That's no contact. It's that simple. But if you post a bond for her, she'll be released. Lastly, we're going to give her notice for her next court date, which would be December 2nd.
1st.
December 1st at 9 a.m. will be your court date. Ms. Pravat, I'm going to ask the jail to give you that notice after first appearance. So your daughter and son are here, and I'm assuming they're going to be trying to post bond for her. They said they're going to be trying to post bond this morning, ma'am, and if they post bond for you, will be released. Just make sure you have no contact with this person, follow those other rules, and be in court on the December 1st at 9 a.m. Ms. Pravat, do you have any questions?
Yes, I do.
Okay.
I had my door. I could not, that
Ms.
door.
Pravat,
wouldn't
don't
lock.
talk about, remember, I asked you, don't talk about the case, okay? That's going to go to a jury, not today, ma'am. Just remember also, just as a word of advice, you heard that last case, do not do not talk to your neighbor. You need to turn the other way and go another direction, because if there's allegation y'all are talking and arguing out there, you're going to be sitting in jail. I want you to be clear about that, okay?
So, Ms. Pravat, just talk to your attorney in private. I don't think you have any questions. I think you want to tell your side of it, which is fine. It's just, this is not the time to do that. The time to do that is after you talk to the attorney in private. Does the family have any questions? All right, Ms. Pravat, wish you the best, ma'am.
Thanks.
Next case, we have no one else here on first appearance case at the jail. So we'll go back to the take the first two, Brittany Parker and Charles Parsons. Yes, ma'am. Absolutely. Thank y'all for coming. Let me see Brittany Parker and Charles Parsons. Ms. Parker, Mr. Parsons, good morning. I'm seeing you at the same time because your cases are identical for first appearance purposes. Each of you are accused of violating the terms of your state probation, and in each case, the circuit judge has signed a no bond warrant. What that means is I'm going to go ahead and get you arraigned this morning because I want to get you a lawyer appointed if that's what you're asking for, and I can do that once an affidavit's been filed, as it has in your case. Ms. Parker, would you like to have an attorney appointed to represent you?
Yes.
All right, Mr. Parsons, same question.
Yes, sir.
I'm going to appoint the Public Defender's Office of the 14th Circuit to represent each of you. Listen to your attorney for today, Mr. McDaniel, and then we'll see if you have any questions in just a moment.
Your Honor, we're going to plead not guilty. He has to set this on the December 4th pretrial docket, and I advised them both, Mr. Green, to come by and talk to them prior to that hearing.
December 4th, Mr. Mitchell, anything?
No, Your Honor.
Ms. Parker, do you have any questions, ma'am?
No.
No questions? Have a good day. Mr. Green will see you before your court date. Mr. Parsons, any questions?
Yes, sir. I have a drug problem. That's why I'm here. I feel the UA and I have a drug problem.
So, Mr. Parsons, what I would suggest is talk to your attorney about that. I don't really know much about your history in this case, Mr. Parsons, but if it's something that you're interested in, and if the state agrees, and if most importantly, the judge agrees, that may be something they can address in a sentence, such as some type of inpatient treatment. But there are a lot of factors involved, such as have you ever been before? What's your overall criminal history? How long have you been on supervision? There's a lot of factors, but talk to your attorney about that in private first, okay? Have a good day, sir.
It's likely it's going to be my case, so I'll take that into account.
Thank you. Thank you, Mr. Mitchell. Laura Raffield. Ms. Raffield, good morning again. I saw you yesterday for some other charges. After first appearance yesterday, you've been accused of 3 new charges. They are trafficking in methamphetamine, smuggling, which is introduction of contraband into a county detention facility, and tampering with evidence. There is probable cause for these charges, ma'am. I'm going to ask you to listen to the attorneys before I address your bond status. Mr. Mitchell, anything from the state?
Judge, we would just ask that you move to revoke her bond in the case that she was first appeared for yesterday. I don't know if it's been assigned a case number yet.
Let's see if do you have a case number already? Okay, so before I hear from Mr. McDaniel, I texted y'all this morning and said if that's something the state's going to be asking for, put some thought into it. So tell me, the question is, did any of these charges allegedly occur after the bond was set? So Mr. Mitchell, let me hear from you on that.
Based on what I could see in the complaint, I think definitely the tampering happened after the bond was set, before she was taken to Jackson Hospital. And there is arguments, I can't remember what we were discussing or what the terminology was, that it was a continuing charge involving the trafficking case. And
there's no trafficking.
Ma'am,
Don't speak, ma'am.
And I think it's also a continuing charge for smuggling the contraband. So I understand that there's continuing circumstances when it comes to the trafficking and smuggling contraband. But the state would argue that the tampering is definitely a new charge that happened after bond was set. So based on that, that's why we petitioned that her bond be revoked in 25545 CF.
Let me read that statute, Mr. McDaniel, before I hear from you. I'm concerned about 893.02 subsection 4. That can't be right. I think it's going to be 951.22. So there's a different statute for correctional facilities, state correctional facilities, and county correctional facilities. So the county one, which is what officers charged here, says it's unlawful, except through lawful channels, to introduce into or possess upon the grounds of any county detention facility. Okay, so Mr. McDaniel, would you like to be heard, sir?
Sergeant.
Your Honor, I would just argue that, this is a continuation of the same crime. Essentially, she was taken into custody while she was at DOC. She was in custody, has been in custody since that point in time. So whatever crimes also happened at DOC, this could easily be always a continuation of the same crime, including trying to hide it. That was all being done at the same time. They didn't find it until, essentially right after first appearance yesterday. But it is, she could be charged, I think the exact same charge crimes with the DOC also, because she was taken into custody and she never had a chance to put those things inside of her body. I think the state can easily make an argument that these are all the same crimes in that same felony case. I don't know if she's going to post bond, but I would just argue that it, based on the circumstances of this being one continuous crime that continued on through the process of yesterday, that, revoking her bond is, holding her without bond is probably a very high, extreme kind of position to take on a case like that, where it's just the same crime that's been continuing.
Thank you. So, Sergeant Gross, are you in the room out there?
Yes, sir.
Can you come up to the microphone? So the chief called me before this all happened and was asking, was it possible to get a search warrant? And I explained to them the search warrant process, how it all worked. They need to contact law enforcement and so forth. But what my understanding was, the first incident happened, she comes to jail. An officer thinks she sees something on her body, but Miss Raffield supposedly wouldn't consent to a search. She goes to the hospital one time. At the hospital, she refuses medical treatment. So they take her back to jail. And then that's when the chief calls me. I said, well, here's how a search warrant works, because this is a very unusual situation for the jail. Y'all don't deal with search warrants very often. So you might be able to get inside of her body, but here's the process. Here's the burden of proof. Here's how a search warrant process works. I don't hear anything else. We first appeared her yesterday, and then after first appearance yesterday is when this current case happens, and the complaint says she essentially comes to y'all and says, I do have something inside of my person, and I can't get it out. Is that your understanding of the timeline, Sergeant?
Yes, sir.
Okay. And then the complaint alleges that she was able to remove some of the methamphetamine and flush them. Supposedly she said this. Just a second, ma'am. The complaint says she claimed, she told him she removed some of the methamphetamine and flushed it, but she couldn't get at least one package out. And that's when they went to the hospital. And that hospital yesterday, the second trip to the hospital, they successfully removed the methamphetamine. Is that the timeline as far as you understand it, the allegations?
As far as I know, yes, sir.
So, Mr. Mitchell, that the phone call about the search warrant may have brought something else to the state or the defense's mind. And it's irrelevant, other than she made 2 trips to the hospital, not 1. That's at least my understanding of the timeline. Mr. Mitchell, anything else from the state knowing that additional information?
Nothing additional, Your Honor.
And the law, I never saw a search warrant application, so I'm going to go out on a limb and assume they didn't apply for one, because I would have seen it. Mr. McDaniel, anything else?
Nothing, just Your Honor, it's just a continuation. Even the other part of the crime happened prior to first appearance. She continued the crime, but all these things they're all the exact same crime, Your Honor. We just asked that she set a bond on these charges, and we'll probably see her at a jail arraignment, I suspect, after talking to her.
Ms. Raffield, it appears to me that based upon the timeline, the allegations are you had that substance inside your body at the time I first appeared you yesterday, and then after first appearance, became worried about not being able to get it out. Told law enforcement or told. I'm just telling you the timeline, ma'am. I don't want you to comment because I don't want you to hurt yourself. Okay, I'm not trying to cut you off. I just don't want you to hurt yourself, and that's what I'm afraid is going to happen if you talk about the allegations against you. And then the crime is possessing. Arguably, there's probable cause that you committed the crime of possessing after I set the bond. But it's just a weird timeline. What I'm going to do is I'm going to set you a higher bond than normal because I think you were committing a crime probably when I first appeared to you yesterday. So I'm not going to revoke a bond, but I'm going to set a bond at $100,000 on this trafficking and $50,000 on the smuggling and $25,000 on the contraband. So your bond today is $175,000 in addition to whatever it was yesterday. Before, ma'am, because of the timeline, as I understand it. But I'm not comfortable revoking her bond because of the argument Mr. McDaniels made that it's a continuing crime. So you've got that bond, ma'am. Anytime your bond changes, you have the right to use the phone, ma'am, to contact friends or family.
They never let me use it. They never let me use it yesterday.
Okay, I'll get to that in just a second. Just a second. I'll come back to that. You do have a condition of random urinalysis, and you're also going to have the same court date you were given yesterday, which is December the 2nd at 8:30. So you were saying you weren't able to use the phone yesterday?
I wasn't able to use the phone, and really, I just want a speedy trial so y'all can go ahead and sentence me and send me on.
Okay.
Can we do that?
No, I can't do that. I'm just the first appearance judge. Sergeant, what do you know about the phone use?
Well, she's been on suicide watch, so she doesn't have access. She's in the process of talking to life management right now. So as long as she clears her, then she'll be able to use the phone.
Can you lose your right to contact someone for purposes of posting bond just because you're on suicide watch?
I don't think so. And I think it was just because of all the stuff that was going on yesterday. My expectation is the jail's going to let her use the phone this morning to try to post bond. I don't think she's going to be able to post bond, but I think the jail will be letting her use the phone for posting bond, letting know family members where she's
Sarge, what I want to instruct the jail to do is contact the county attorney or the county manager, county administrator. I have no idea, but that rings of me if a jail says they're on suicide watch, therefore they lose their constitutional right to make the phone call. That just doesn't feel right. I don't know if it's appropriate or not, but my suggestion is y'all contact the county attorney and ask them to research that issue. Mr. Mitchell, I'm going to ask the state to research it also, because I just that smells like it may be a violation of her constitutional rights. So I don't want y'all to get accused of violating her rights. Certainly she needs to use the phone this morning. Ma'am, I wish you the best. I wasn't clear.
On the tamper.
And 100 on the introduction, 175.
Yes.
Okay, so that takes care of Ms. Raffill's case for today. The next case is Robert Brand. Mr. Brand, good morning. You're here because you've been accused of one count of driving under the influence. Mr. Brand, there is probable cause for that charge. It also appears to me that you're already on probation in Jackson County case 24- can't read my hand. I think that says 16 CF. Mr. Brand, I'm going to appoint the public defender's officer to represent you. I'm going to ask you to listen to Mr. McDaniel, your attorney.
Your Honor, I spoke with Mr. Brand. At this point in time, he's going to plead no contest to the charge of DUI. The understanding, he'll be sentenced to 90 days in the county jail. There'll be $1,078 in fines, 1-day jail credit. He has waived his right to a jury trial and call witnesses. That'll resolve the case today. And Mr. Brand, I have talked to the prosecutor, and I think you're going to be all right in the felony case, just as I told you before. Okay, sir? Can't make promises.
Say that again.
I did talk to the prosecutor, and I think what I told you when I was at the jail is going to happen on that state probation case. Okay. So I can't make promises, but I think that's what's going to happen though. Okay, sir?
So it looks like I'll be here for the 90 days and then continue on.
So Mr. Brand, Mr. Mitchell, the prosecutor, is also the prosecutor in the violation of probation. So I want to ask him to expound on that a little bit and tell you what he's going to be asking for in the VOP. Now, this doesn't mean the judge will accept it. but this is what the state's going to be asking for. I heard them talking about this morning. Mr. Mitchell?
Yes, Your Honor. Based on the information that was provided to me, it looks like he was 2 months out from completing his probation. So more than likely because he wants to go ahead and accept this plea today, I'll probably I can't guarantee it yet, but my intention is give him,
Unsuccessful termination.
2 extra months, and then unsuccessfully terminate him at the next VOP date.
So let me ask you a question, because you said probably, and you said I can't guarantee it. Are you saying that because you don't know the judge will accept it, or are you saying you don't know if you'll offer that?
First part.
Okay, so you're going to be asking for that.
I'm going to be asking for
But you
that,
can't
yes.
promise whether Judge Garcia will accept
Yes,
that.
yes.
So the state's going to be asking, in light of you getting the 90-day jail sentence and considering the charge you're on probation for, which I think was a felony driving license suspended, and most importantly, perhaps considering how close you are to completion, Mr. Mitchell's going to be asking for what he just said. No other punishment other than 90 days and perhaps adding additional probation of a couple of months is what I'm understanding him to say. Mr. Brand, knowing all of that, do you have any questions about the plea agreement that your attorney put on the record?
So just so we're clear, right now I'm looking at 90 days and then he's going to offer me another 2 months on my probation to complete that 2 months.
Mr. Mitchell.
What I meant by the 2 months is I was saying, if possible, we could set up for the January 8th VOP date. That way it sort of satisfies the 2 extra months as.
I won't set him for a VOP date at all because there's no affidavit filed by the probation office.
All right. Disregard everything I just said about the 2 months, but
you're not asking for additional sanctions other than the time he's already getting on the misdemeanor.
Correct.
Anyway. Is that right?
Correct.
Okay. Mr. Brand, does that answer your question?
Yes, sir.
So given that, which is all on the record this morning, is this the plea you would like to enter to resolve this DUI charge?
Yeah. Yes, sir.
And Mr. McDaniel, you want that standard condition that the plea won't be used against him?
Yes, Your Honor.
Mr. Brand, I'm going to accept your plea of no contest to the charge of driving under the influence. I'm going to judge you guilty of that offense, sentence you to 90 days in jail. Court costs and fines of $1,078 will be imposed. You'll be given credit for 1 day served. Mr. Brand, the plea itself cannot be used against you. If the state does try to use the plea against you, I'll let you withdraw this plea. If this is only violation, which you just heard Mr. Mitchell talk about, then his intent is to ask for no further punishment other than the 90 days based upon you were punished for the DUI, you were almost completing probation, and you had successfully done about 22 out of 24 months of probation or thereabouts. The court costs and fines, I don't know if I said that, $1,078. You certainly may qualify for a trustee program. You may or may not. That's between you and the jail, but you will need to talk to them about that. And then once the probation office files the affidavit of violation of probation, you'll get arraigned and you'll get put on the VOP docket. Just as Mr. Mitchell said, that very well may be the January docket. So you'll still be in jail finishing the sentence. Mr. Brin, do you have any questions?
No, sir.
All right, sir. Wish you the best. We have Tamara Jennings. Ms. Jennings, good morning. Ms. Jennings, you're here. I first appeared to you yesterday on a violation of state probation charge. There was some concerns and questions. You turned yourself in apparently, or that's what I was told. And then there was some concerns about the payments being made, when you made it, did you make it? So I said, well, give the benefit of the doubt. We'll bring her back tomorrow, give the state and defense time to look into this. Listen to Mr. Mitchell first, the prosecutor, and we'll see what he's been able to find out.
Yes, Your Honor. I spoke with probation yesterday and they were not able to find any documents showing that there were payments made. They also there may be something else, but they need to look further into it. We just say for right now, we keep her on the December 4th VOP date. Is it December 4th?
December 4th or December 3rd?
4th.
December 4th.
We're still on the cutoff.
December 4th, my list is wrong.
That's.
I'm looking at the wrong year.
Wrong list, yeah.
Thank you. This one says December 4th for this year. So next year will be December 3rd. Okay. So December 4th at 8:30. Mr. Mitchell, thank you. Mr. McDaniel, anything on behalf of Ms. Jennings?
Your Honor, just in case I didn't say it yesterday, I'm just going to enter plea of not guilty and ask her be placed on that December 4th court docket. Guy Green to come by and speak with her. Your Honor, this is a situation where, she drove from South Carolina and turned herself in. So she obviously, I don't think is a big flight risk. And she could down and turn herself in. We would just ask if we could consider setting a cash bond, maybe a $5,000 cash bond that way. And that doesn't mean not to talk to her. She's still got to be here on December 4th, her court date, which is happens to be her birthday also. So she plans on being back here. I'm not swearing she's going to be able to pay that $5,000 cash bond, but that would significantly help the court's ability to believe that she will be back for that court hearing if she paid a $5,000 cash bond, Your Honor. Not to mention that money could go back toward a restitution that might be owed in the case when they come to a resolution of the violation of state probation.
Thank you, Mr. Mitchell. I'm not going to mess with Judge Garcia's bond, but I do want to know the state's position on that request because I want Ms. Jennings to hear whether y'all are in agreement with that, the $5,000 cash bond request.
We'd have no objection to a $5,000 cash bond. I can get in contact with Judge Garcia and see what she says about that.
Ms. Jennings, I'm not going to set a bond in her case without her being involved in that discussion. What I'm going to suggest is that the two attorneys email Judge Garcia, and she certainly, when she gets that email, she can take a look at the case, and she's very, very diligent, stays on top of her stuff very well. And if she determines that the cash bond is appropriate, she can do that. If she's out of pocket for some reason and she wants me to do it, then I'm glad to do it also. So right now you got no bond, but there may be a bond coming in the very near future. Mr. Goodson. That's incorrect. That was, yeah. There are 3 or 4 victims. The arrearage, and I'm basing this on the affidavit itself. So whoever you talked to didn't read the affidavit. The affidavit filed by the probation office says one of the victims, the arrears is $1,950. Overall, she's paid just about nothing, and she owes like $28,000 or $29,000. Yeah. Yeah, I think you got some bad information. At least what the probation officer is saying doesn't match what her probation officer filed with the court. You're not claiming to have paid $27,000 or $28,000 in restitution since you're on probation, are you, Ms. Jennings?
No, sir.
Yeah, so the probation officer was just wrong. It appears. So, Ms. Jennings, you've got no bond for right now because that's what Judge Garcia said. Judge Garcia may or may not change that. Do you have any questions, ma'am?
I do have a question. As far as the arrearage with them stating that they don't have those receipts or that documentation, if that information is found, which I have my family members working on that right now.
Yes, ma'am.
Would that mean anything? Would that cause me to come back in front of you or?
It won't, you wouldn't come back in front of me. It's not my case. I've seen you twice. Judge Garcia is most likely going to be the one to see you unless Judge Garcia says, Judge Mercer, can you go ahead and handle this at first appearance and set her bond? I'm glad to do that. But to answer your question, I don't know if that will change things or not. What Mr. McDaniel's plan now is to get you a cash bond. Hopefully, he's going to try. And if Judge Garcia sets the cash bond, you post the cash bond and you're released. And then if that money comes through eventually, then that gets processed also. Did I explain that correctly, gentlemen?
Yes, Your Honor.
Yes, Your Honor.
All right, Ms. Jennings, wish you the best.
Ms. Jennings, let me ask you one question, I guess, because you went to I had you go make a phone call. If I go through all this work to get you this cash bond, are you going to be able to post that cash bond?
$5,000, I can try. It's kind of steep because I live in
I'm
South
just asking,
Carolina.
I don't want to go through all this work. If you know you can't, then I'm not going to do it. If you think you
I have
can,
people
then
that are gonna try to do that for me.
okay. All right. Well, I'll see what I can do, ma'am.
It is a lot of money. $27,000
Right.
convicted of stealing is a much greater number. Okay, ma'am.
I understand.
Wish you the best, ma'am.
Thank you.
Yes, ma'am. Mr. Jailer, I think that's it for first appearances unless I missed something. Anything else from the jail, sir?
No, sir.
Mr. Mitchell, anything else from the state?
Nothing regarding the jail.
We do have one case in the courtroom. Mr. McDaniel, anything with the jail?
No, Your Honor.
So, Mr. Jailer, we do have one case in the courtroom, but I want to make sure Judge Garcia doesn't have anything or another judge. Is another judge waiting on the use of this video room as far as you know, Mr. Jailer?
Not as far as we know now.
All right, good deal. We're just going to stay on this same connection. We appreciate you, and we'll see you next time, okay?
Yes, sir. Thank you.
Thank you. And Mr. McDaniel, what case do we have in the courtroom?
We have Christian Carter, 25522 CT.
Mr. Carter, come on up, please. Mr. Carter, I'm pulling up your case now. Mr. McDaniel emailed myself, the clerk, and the state, I think Monday, about a possible plea. So what Mr. McDaniel does is he tries to stay on top of his cases. Probably the most organized attorney I've ever worked with. So if he gets something worked out, instead of waiting on a court date where there's 50 other people, he'll try to bring you in early. So that's what he's trying to do. So I'm going to ask you to listen to Mr. McDaniel, and we're going to see where we go.
This right here is waiving right to jury trial and call witnesses in U.S. Separate plea from the court signed here, which date of birth.
Mr. Carter has a $1,200 cash bond.
Your Honor, I spoke to Mr. Carter. He's going to enter a plea of no contest to charge of DUI, 11 months, 29 days probation, stipulation less than 0.15 with alcohol content, 50 hours community service, $1,078 fines, which we paid via his cash bond that he paid. There'll be a minimal driver's license suspension, AA classes as directed by probation. If you're adjudicated guilty, he has waived his right to jury trial and call witnesses. And he's already signed up for this alcohol classes, which will probably take care of his AA classes. And I think the schedule will start that here next week or two, maybe.
Yes, sir.
So, I mean, and he'll provide all that stuff to probation. So he may not have to do the AA classes, but that's at the probation.
Mr. Mitchell?
That is agreeable with the state, Your Honor, and he was set for the December 1st arraignment. So since he's entering that, we can take him off that arraignment docket.
Mr. Goodson, anything from your perspective? I think it's a first offense DUI.
Yes.
First DUI. I did look at the driving record. I didn't have the criminal history, but you told me the criminal history was one minor charge several years ago, Mr. Mitchell.
Yeah, that was dropped. So he's basically got nothing on his record.
Miss Williams? It wasn't above 0.20. It was up.
We're also
0.17.
stipulating to under 0.15.
But yeah, for purposes of the plea, it's less than 0.15. Mr. Carter, did you hear all that, sir?
Yes, sir.
Do you have any questions about that agreement?
No, Your Honor.
Mr. Carter, is that the plea you would like to enter?
Yes, sir.
Mr. Carter, I'm going to accept your plea of no contest to the charge of driving under the influence to less than 0.15 blood or breath alcohol level. It's case number 25-522 CT. I'm going to judge you guilty of that offense. I'm going to sentence you to 11 months and 29 days probation. Mr. Carter, you will have the standard conditions of probation. In addition to the standard condition, you will have the following special conditions, most or perhaps all of which are required or mandated by Florida law. Court costs and fines will be ordered in the amount of $1,078. They'll be paid from the cash bond. So whoever's name is on that cash bond, the balance of that, which would be, it was $1,200. So that's $122 will go back to whoever's name is on that cash bond unless they agree for it to go towards cost of supervision. Is that person in the courtroom now who posted it for you? Okay. So when y'all get downstairs, y'all can either say, I want that $122 back, or I just want it to go towards this cost of supervision. Your cost of supervision is $40 a month, only for the months you're on. So hopefully you're going to get off at the halfway point. So if you get off at the halfway point, you won't pay cost of supervision for the last 6 months. You'd only pay it for the months you're actually being supervised. Successfully complete substance abuse counseling. As Mr. McDaniel said, I do allow credit for the class, the DUI school, as long as you enroll within 60 days. It sounds like you are.
Yes, sir.
The DUI school is 16 hours. You only have to do 12 hours of counseling. So if you enroll in DUI school and complete it, that will fully satisfy your counseling requirement in probation.
Okay. Awesome.
Now, driver's license division may make you do something else, more counseling to get your license back.
Yes, sir.
But as far as probation goes, you'll be fully completed it. 50 hours of public service work, which are also set by state law. You also have the right to work those off if you wish, or pay them off, excuse me. I do recommend the minimum driver's license suspension. Mr. Carter, it's possible to get off probation early. In order to get off probation early, you have to have the probation, have no violations, get everything completed. And then the probation office requires, or I require, that you be gainfully employed, legally disabled, or full-time student. So if you qualify, you can get off probation early, hopefully at the halfway point. Mr. Carter, what we're going to do is get you some paperwork. We're going to get you to see Mr. Goodson. Mr. Goodson is your probation officer. He'll get you downstairs. They'll get you instructed. They'll give you a copy of all the rules in writing. They'll give you a chance to ask any questions, and then you'll be free to leave. Do you have any questions you want to ask me about your sentence?
No, sir.
All right. So see Mr. Goodson over here. I wish you the best, sir.
All right, thank you.
Yes, sir. Please. Thank you for getting that brought up early, Mr. McDaniels. That's one less we got to lower our docket by one. That's everything I have.
All right, as he's finished up, it's Wednesday. It's the Courtroom Files Live. Happy Wednesday to everybody. It's good to have you here. Looks like there might be some new people out there. If you're new here, haven't been here before, please do say hi in the chat. We are a friendly, lovely community, and we're happy to have you here. So announce yourself. Let us know who you are. Let's move to Texas. Let's say good morning to Judge Stevens.
I'd like to possibly get a reset.
So where are we on it?
Working on it, Judge.
What does that mean? We're working on it.
Talking to Mr. Boyd, maybe working something out, but I need to give him some.
What was the last meeting y'all had?
This morning, walking in.
And what before that?
I don't know.
Are we really working on it or?
I was looking at it this morning, trying to figure out some of the legal issues associated with it. You're about 80 days on this case.
What is the time limit on?
There's no time. I just know that it's a young case, still in its infancy.
Like I never tried anything before. So it's 45 years, but I know how it works. Mr. Ozan, what are you doing right now for a living?
Sir,
what are you doing for a living?
I'm working on Texas Tank Wash.
Okay. Is that full time?
Yes, sir.
Okay. How much are you making an hour?
Well, right now I'm at $22.
Good for you. Well, that's, but it'll go up a little bit, won't it? After, how long have you been there?
Well, I just got there about 5 months ago, but my previous job at Amstel, I was there for like 3.5 years.
How much were you making then?
27.
And I dismissed it. Well, that's 20%, 25% more. But do you have a chance of getting more income here over time? Or is this going to be?
No, it just
well, 22 an hour gets you about 45,000 in a year, but you're working full time?
Yeah.
Okay. All right. On this mess, this all happened on July 4th, huh? So these,
that's right.
That's correct, Your Honor.
Louisiana too. That was the plaint, I think.
All right, how many times have y'all had a chance to discuss this?
A couple times, Judge.
Well, it's my second time from the time I went to court.
Uh-huh.
The third time we were basement.
Does he have a prior conviction? Do you have a prior conviction for anything?
Not in Texas,
No.
sir.
Okay. Anywhere on the planet, do you have a prior? Is it a felony?
Louisiana.
Is it a felony?
Accepted possession of marijuana.
Well, what happened in that case? What was the punishment?
I had they gave me 5 years, and I had to do 3 years on me.
Yeah. Oh, you went into prison for 3 years?
Yes, sir.
How long ago was that?
2000. I came in 2015. I came home. And I got paroled in 2018.
Okay. Well, that could affect, the way this heads, but how much time do you need?
Shortly said, Judge, 3 weeks.
Okay. All right. State, you were kind of wordy here.
That's fine. We've made an offer on it. Think we could. I'll check into the Louisiana stuff too to see what he has that may affect.
He might not be able to get regular probation.
Yes, sir.
If he's kind of fallen from a jury anyway. If you have a felony conviction, in this state or any other state or the federal government, it forecloses a jury having the opportunity to to grant probation, but 3 weeks, okay? See where we are. Okay, no, thanks. John? No. Audie? What? Okay, what are we doing today?
We get a couple more weeks, Your Honor. He was supposed to come in and look at discovery, but I've been in trial as you know. So we had
For 3 days.
discovery. Yeah. So if we can get a couple more weeks, we should be able to look at everything and make a decision. Or well, I would say 1 week, but that's the holidays. But if you give us
3 weeks?
3 weeks is great. Yeah. If we say
Stelling? Michael Stelling?
I've asked Mr. Stelly.
Mr. Stelling, Michael Stelling is called 24 CR 1782. No answer in the courtroom. I am going to ask the bailiff to please call into the hall for Michael Stelly. Thank you.
Michael Stelling. Michael Stelling.
What's his bond?
No response.
There's no response to the name called here in the courtroom. No response to Michael Stelly, the name called by the bailiff into the hallway. Defendant has failed to appear. His bond is revoked. A warrant shall be issued for his arrest. Among other things, he shall have a GPS device on him as a condition of bond. 15. His bond was $15,000. It is revoked. It is doubled to $30,000, and a GPS device must be acquired on him so we know where he is when he's not in court when he's supposed to be. Yeah.
Just show up, folks. That's rule number 1. I don't know how many. I think it was Fleischer that used to say, if you just show up, good things will happen. Yeah, do that. But what just happened there for that guy, not so good. Let's go up to Michigan. We'll say good morning to Judge Simpson. And good news, young Reagan is back.
I'll give the adjournment rather than setting up the final settlement conference. Young lady, do me a favor. You've been up here before me, what, a gazillion times? That's a number. You've been here, right? Of what I know of all of your cases, listen to your attorney and go in that direction. That's going to be the best for you. I'm just going to tell you that. I mean,
Okay.
you'll make up your own mind, but I think you're trying to do stuff that's just going to be disastrous for you. Keep going down the route that you're going down. You hear me? Okay.
Thank you.
The way you've been living your life, when you don't have people to kind of help you choose, that hasn't worked out too well.
I understand completely.
Right?
Yeah.
Because that's why you're before me in green right now. So maybe listen to somebody else, do something. It may sound like hard work, but in the long run, it's going to be the best for you. And I wouldn't say that if I didn't think that's true. All right. I'll adjourn this out to December 17th, 2025.
Thank you.
Thank you, Your Honor.
And I'm getting sick and tired of seeing you. No, I'm kidding. I'm kidding. I just had to throw that in there. Court calls the case of the people versus Rickard Tupso.
Spell this for the people.
You went to the restroom. Can you pass for a second? I'm sorry.
Burgess, man. Oh, yeah. I was going to come back. You knew that. Fine. I'll pass.
Thank you.
Court calls the case, people versus Alicia Allen.
Conrad Siller on behalf of Pittsfield Township.
Assistant Public Defender Lauren Perny on behalf of Miss Allen. State your name for the record, please.
Alicia Allen. All right, I have before me a plea form that indicates she's going to plead to an added count 2 of allowing an ineligible driver to operate a motor vehicle to 90-day offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
All right, very good. May I have her sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, self you got.
Yes.
State your name.
Alicia Allen. Ma'am, it is this court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That is a misdemeanor punishable by up to 90 days incarceration, $100 fine plus court costs. Do you understand that?
Yes. Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
All right. You had signed an advice of rights form, is that correct?
Yes.
Any question about any of those rights?
No.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
Which one?
Probation.
Okay. Were you on probation at the time of this offense?
Yes.
All right. I do have to advise you then that this could be considered a violation of probation. If it is, the other court could sentence you to the maximum allowable under that other charge. You understand that?
Yes.
Still wish to plead guilty to this charge?
Yes.
Anybody promise you anything other than what's been stated here today on the record? Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe you're guilty?
Yes.
All right. On the date of February 27, 2025, at the location of Carpenter Road, Pittsfield Township, Washington County, State of Michigan, did you have custody or control of a motor vehicle?
Yes.
Did you allow someone who was otherwise ineligible to operate that motor vehicle?
Yes.
Counsel? Well, I do have to advise you that between the time of sentencing and the time of this plea, if you commit misconduct as defined in the Michigan court rules, court would not be bound by any sentence evaluation and or recommendation, and you would not be entitled to withdraw your plea. You understand?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No. Yeah.
And have I complied with the court rule?
Yes.
Yes.
Court will accept the defendant's plea to count 2. Count 1 is dismissed.
Your Honor, regarding sentencing, if I may.
Can I stop you? No, go ahead.
Ms. Allen has been in custody for 38 days, correct? She is being held on a felony. Her next court date is before Judge Hamoud on December 1st. So she'll be in custody for at least another, what would that be, a week and a half, depending on what Judge Hamoud does. She's asking for a credit for time served sentence.
Why would I do that?
Because she's been in for a while. She resolved the case. She's probably going to go to treatment when she gets out. It's a lot of money. Shall I stop there?
No. If you want to keep going, you just keep going.
I think that's all I got.
Wow. Ma'am, anything you want to tell me before I do a both sentence?
No.
Not going to ask you that.
There.
All right. Fines and costs just go to the minimum $125. 38 days in jail, credit 38, sir.
Thank you.
Thank you.
Court does call the case of the people versus Latrell, Washington.
Conrad Solar on behalf of Pittsfield Township.
People. Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Washington. I'm not sure if Mr. Washington is present. I've reached out.
He is.
Oh,
Latrell, Washington.
Yes.
State your name.
Latrell Washington.
All right, you need to turn on your camera.
Yes.
Thank you. All right, what are we doing?
Your Honor, I have not had contact with Mr. Washington, so I request an adjournment. Last year, I asked Mr. Washington to call and update his phone number. I'm not sure if he did that, and I'm calling new phone number or the old phone number. So Ms. Rushing, if you've gotten my calls, call me back. If not, call the public defender's office and update your contact information.
Oh yeah, I actually updated my number already.
When?
I updated my phone number after the last court date.
I'll adjourn December 3rd, 2025, 9 a.m. Bond continued. Make sure they've got your number.
Okay.
And an email.
Okay.
All right. Otherwise, I'm going to make you come down here and they'll get it right from you.
Okay.
Thank you. Bond continued.
I preach a lot here about the importance of family and having a, tight-knit system within your family. And Grandma TCF, my mother, proves that out. $10 super chat. Thank you, Grandma. Thank you, Mom. Appreciate it. Love you very much. Thank you. And happy Wednesday to you, too. I hope that chat you had with your arthritis put it in its place.
See you, Darwin.
Thank you.
Your Honor, we're requesting an adjournment to view the media together. It's quite voluminous in this case. Mr. Godwin is being held on a Judge Conlon case. He sees Judge Conlon today. We believe he's going to be released today, if that matters to you for the next date.
December 3rd. Will that be enough time for you to get through all the media? You're indicating that it's a lot. You don't always do that. I mean, I can give you the 3rd or the 17th if you really think he's going to be released.
I'll take the 17th if that's okay.
All right.
Thank you.
December 17th, 2025, 9 a.m. Bond continued. Of course, Miss Perrini. I don't know why I'm being so nice to her.
I appreciate it.
Okay. Recalls case people versus Rick Artuso.
Good morning again, Your Honor. May it please the Honorable Court, David Burgess on behalf of Rick Artuso, who's approaching.
Your name?
Rick Artuso. Your Honor, he's being sentenced in front of Judge Conlon on December 3rd at 1:30 p.m. I was going to ask for a date after that. Ms. Feltus, I believe, is in agreement with that.
That's correct, Your Honor. I don't know, for some reason he didn't take screening when he was in custody, so it got adjourned.
That's correct. They delayed the PSR for some reason, Your Honor. I don't know why.
December 17th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Court calls the case of the people versus Joseph Griffin.
Conrad Siller on behalf of Pittsfield Township.
Good morning. Assistant Public Defender Lauren Perry on behalf of Mr. Griffin. Mr. Griffin, state your name for the record, please.
Joseph Burton Griffin, Your Honor.
The corporal gives tell you got to move, lady.
No, he said.
Oh, no, I'm just kidding. I'm just saying how I saw. All right. No, go ahead.
I'm always in the way, so he gave me the right of way. Your Honor, this case is a drug paraphernalia case. It can be resolved if Mr. Griffin goes to treatment court, or not treatment court, drug treatment. He is hopefully going into drug treatment court. So we're asking for an adjournment for all that to take place. He has a couple of cases set before you tomorrow on the PCC docket.
So are they trying to get him into felony drug court, or?
Yes.
Is that what?
Yeah.
Okay.
And he has releases on, I think, all of the other cases, and we'll get paperwork into you if
To release on this one.
if Mr. Stiller agrees to release on this one as well.
I'll leave that to the court's discretion.
All right. Thank you, Mr. Stiller.
Yes.
I'll adjourn the matter then to, well, has he started that process?
He's
No.
been accepted.
Oh, he has.
He's released me. Also.
Yeah, he's been accepted into the program.
The felony drug treatment court.
Yes.
Okay. Okay.
He's also released me.
Well, why don't I would do the 3rd, but you think we need the 17th to get everything wrapped up?
So the other complicating factor is he has a hold out of Wayne County. So that's got to be resolved before he can be released here. And obviously getting a hold of Wayne County can be difficult. So we're working on that. So I don't know if we'll get, I mean,
Why don't I do this? Let me make it December 17th, 2025, 9 a.m. If for whatever reason, everything gets worked out before then, contact Ms. Whiteling and we'll see if we can move it up on the docket for him. Fair enough.
that's good.
Okay.
Thank you.
Thank you.
Let's move back to Texas and back to Judge Stevens, new contestant there.
Older than me.
Well,
And I'm old.
it's because you're so young.
This was, you know how old this thing is? You had hair.
Yes.
You had hair. Oh, you know, when this was filed.
You missed this, haven't you? So
Good to pass that up.
we have, I appreciate it.
How's it? You had a meeting
We have,
talked to him?
yes, Judge.
How's that going?
It's cool. Great. That's great. We have worked out a deal, we believe, for the state. It's going to be a little bit unique from what we normally do, but we've agreed.
What else is new here in this room?
Yes, Judge. It's,
Unique kind of place.
so what we would like to do is enter a plea with you today, and with an agreement about the outcome. But what we have a dispute about is about the restitution. And the amount of restitution ultimately impacts the level of offense, if that makes any sense.
Yeah.
And so what we would like to do is have Ms. Gallagher plead no contest today to the offense, with the caveat that she, at sentencing, we would have a separate hearing for appropriate restitution, so that we can get that sorted out. We have a dispute about, and a significant dispute about the restitution.
Well, let me just look at one thing. It's a small problem. Short of it. The state a significant amount of cost, doesn't it?
I think it'll be significant in either direction, but I think there's also a significant difference between what we believe is correct with the and this election.
We're a little wordy, interrupting over and over again. This, is there anything you want to add?
No, Judge, we've talked about this. We do believe that the restitution is as alleged, and Mr. Kurtz is saying otherwise. So if we need to have a hearing on the amount of restitution.
There's an issue to the amount, but
I'm going to object to that.
is there money still available to be paid?
Judge, our intention was to, we have a number in mind that's, again, a substantial number. Our intention would be.
No. Is there any loss somewhere circulating that has not been disposed of that can be returned?
That's what I was going to tell you, Judge, is that our intention would be to deliver a check for what we think the correct amount of restitution is to the district attorney's office, or we can put it in the clerk of the court or whatever. But that way she's making a good faith effort, and then we can present our case about what we think it is.
A victim can get anything back because there's not an interest charged on this, like was done when I was in federal government. The federal government is different on that, which I think is the best way. Especially hearing from victims. But if there's something that is available that can be returned, the quicker that is done, the quicker this court is more satisfied, because that is something, because every moment the entity or the person here who is out the money, I mean, every day, if they're out and they could have had something, it's something they can use because they're out these assets that can be used at their discretion, which is the way it's supposed to be since it's theirs. Was the money transferred into other forms of value like property or things like that?
No, Judge, but we've got access to funds that we're going to provide as part of our effort to make a restitution, but again, in the amount that we think.
I know, but it's still cryptic. Where did it go? What happened?
Judge, this is an allegation involving like 11 years
I know, but what happened?
I don't know all the details of where the money went. What I can tell you is it's not like she owns a beach house or something with it. But she's
Was there an illness in the family or something? Yeah, what I'm looking for is where, those kinds of things that there sometimes it certainly goes to the point of whether there was vindictiveness or somebody was facing duress.
I anticipate
that's a lot of money. That's $750,000, right? This is what this says. 768,000 is what it alleges in the probable cause affidavit.
Okay, we disagree with the amount.
That's okay, but I'm just saying what this states. They're generally accurate or close, But if you're saying it was $51,
no.
I'd like to know what the heck is the difference, But it didn't go to somebody's illness or to save a life or anything like that, as far as Okay. No. All right. 2241053 then is called. You are Sabrina Gallagher, and you are here with your attorney, Mr. Gertz, and the state's attorney is here. There is an indictment, man, that was handed up a long time ago and over 3 years now. So it's time this moved forward. And does the defendant waive a formal reading of this indictment? And can we proceed in summary?
She will, Judge.
In summary, this indictment, ma'am, alleges that from on or about April 1st, 2014, and continuing until on or about December 7th, 2020, which is given a 6-year range or so, that you unlawfully appropriated by acquiring or otherwise exercising control over property, namely money, from the victim in this case, with the intent to deprive the owner of that money, and the aggregate value of the property obtained was $300,000 or more. Do you understand what you are charged with here, ma'am?
Yes, sir.
And in theft, the punishment range is primarily based upon the amount at issue that is either lost or otherwise acquired. And this, it becomes a first-degree felony if the value of the property taken or stolen is $300,000 or more. So that's what this alleges as a first-degree felony. It's a second-degree felony if it was $150,000 or more, but less than $300,000. And then it becomes a third-degree felony if the amount taken was $30,000 or more, but less than $150,000. So you can see each tier level steps up from what was a third degree up to a first degree that we talked about. And then a state jail felony if the property is stolen is $2,500 or more, but less than $30,000. So those are the different 4 levels of felonies. So you know where all of this fits. So right now it's alleged as a first degree felony, which carries with it, if convicted, no less than 5 nor more than 99 years confinement in prison or life in prison, and a fine up to $10,000 can be assessed. Do you understand? Mm-hmm. Is there a pad?
Judge, we haven't filled it up yet.
Oh, I thought you were going to enter a plea.
Well, that's what we were telling you what we were doing.
We just
ready to go.
We just wanted to see the best way to.
So you're going
approach
to
it.
Prepare the documents here.
Yes, Judge.
And
then also the
then,
cabinet's locked, so I couldn't get in there.
all right, then let's,
Can you get the key out of the?
I'll get it. Let's get that done. And then, so we enter a plea, pre-sentence report gets prepared. What do you want to do next?
We're going to have a restitution hearing at the time of sentencing.
Okay.
And we have an agreement as to the punishment, that it would be 10 years deferred. Again, what we don't agree on because of the restitution.
What's the victim say?
I have spoken to the victim. He's okay with that. He would like to get his money back.
And what are we talking about? How much is going to be, is going to be forthcoming to tender?
A substantial amount of 6 figures.
Okay, let's try to get as much as quick as possible. Well, because again, we're talking about years that this money has been displaced and at a interest, a marketable interest rate. That's a lot of money that would be added to the loss. That's their assets that they could have used for something on their behalf at their request, not without their permission, you know. That's how I reward people to fix the mistakes as soon as you can and to the amount as high as you can. Okay, please prepare that. We'll go through the please.
All right, we're going to stay in the building, but via the Wayback Machine. So yesterday at the end of the show, we were watching a hearing with Judge West. We had a defendant who had lost a leg, probably karma there, unfortunately. He was not exactly the greatest of dudes. She needed to figure out what she was going to do, and it took her about 2 hours to figure it out. So yeah, there was no way we could stick. But I have that pulled up, so we're going to show that now and see how that concludes. Again, this is from yesterday.
Mr. Malfino, and sorry again, you're Brandon Bell. And so just to get us back where we need to be, everybody's reviewed pre-sentence report, made argument. I want to go back just one more time and see. I know, Mr. Burbank, you're asking that I continue Mr. Bell on probation. With treatment. I know Ms. Lopez has made her position very clear. Ms. Malfino, what is the state's position?
Judge, I certainly have ultimate respect for Ms. Lopez's position. She knows the defendant and what she's been dealing with a lot better, probably has a slightly different perspective on the kid other than what I do, so I certainly defer to her opinion. I also at the same time agree that probably the safety special needs to address that synthetic marijuana issue may be relevant. Has he had that opportunity in the past with some other charges? Yes, very well so.
So what?
Revocation may be appropriate, Judge, based on the underlying offense itself. If it is not, of course, we would be of the opinion that if he goes to that and violates zero tolerance in any way, shape, or form, we ask for that.
Okay, I'm just reminding myself also, so what I did not do previously was go through and take a look at that old pre-sentence report, which has the criminal history, which includes
several sentences in prison.
Already been to prison, given an opportunity on probation in 2020, which is not long ago, 5 years ago, revoked and sent to prison for 2 theft cases. One was a TDC case, given 3 years. And so pretty much gets off parole barely and commits this offense, gets the opportunity at probation, and we're where we are now.
And he does have an extensive juvenile history you will see in misdemeanor as well. And again, that's why I
Yes.
wanted to let the court know that an underlying probation offer was made with the issues with Miss Adriana Bell that the court is obviously aware of by this point.
Okay, I am looking back at history, juvenile history, going back to 2013. Assaults, violation of court orders that look like it should have ended up in Texas Youth Commission. For some reason, they kept putting you on probation all the way until 2018, when you apparently become an adult. Then you start getting felonies and misdemeanors, get probations on all of those. Those are revoked. You beat the mother of your child while she's pregnant. You get a 5-year deferred probation, and you don't take advantage of that probation. I feel like at this time, what Ms. Lopez said is absolutely correct. You are a danger to your children, you're a danger to the mother of your children, and in my opinion, you're a danger, a menace to our county, and have been since 2013.
Just one thing, do you know when his mental health was discovered? Or was it?
Probably when he started using synthetic marijuana. So at this time, I'm going to find that you entered your plea of true. So you were previously in court, entered pleas of true to counts 2, 3, 4, 6, 7, 9, and 10. And then today, I am going to make a finding of true to counts 1 and 8 based on the testimony of Ms. Lopez. I'm going to find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated assault with a deadly weapon. I'm going to sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And I'm going to hand you, and y'all need to sign this trial court certification that shows this was not an agreement. There are some rights to appeal. You can talk to Mr. Burbank about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you. Hang on. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank. You need to sign that, and then I'll get you a copy of it, and then you can go back with the bailiff. I do think that's fair, and hang on to Mr. Bell. I can go up to 20 years today. Talk to Mr. Burbank about that. Yes.
And now we know the rest of the story. Let's go back to today's proceedings now. But back to Judge Stevens, because it looks like the woman who we just saw prior to this Judge West hearing is reapproaching.
You don't act like I care. We now call cause number 22-41053, the state of Texas versus Sabrina Gallagher. Present with Mr. Gertz, her attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
She does, Judge.
In summary, this indictment alleges that from on or about April 1st, 2014 and continuing until on or about December 7th, 2020, it was like a range of 6.5 years, it looks like, that it is alleged that you acquired or unlawfully appropriated or otherwise exercised control over property, namely money, from the owner of this entity with the intent to deprive the owner of the property, and the aggregate value of the property obtained was $300,000 or more, which constitutes the first degree felony of theft. And this was a set of tanning salons, I guess, from what I've read. Do you understand what you're charged with here, ma'am?
Yes, sir.
And a first degree felony, we've talked about that. If convicted, you are facing no less than 5, no more than 99 years confinement in prison or life imprisonment, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
All right. This is what the indictment says. there's an asterisk here on the punishment range. And we're going to have a hearing on the amount of loss, so that we will be able to know exactly where this proceeds. But is it the plan from the defendant and the state that the defendant is committed to admitting guilt in this theft case to whatever level it is deemed that the restitution resulted in, which the court would make a determination of at a later time when all parties have a chance to present evidence.
Correct.
And then what happens there after that? Let's say it's determined, then what is going to happen?
Judge, our intention had been today to enter a plea of no contest to the indictment and then have that restitution hearing, and at which time the court would determine which level of offense and what amount of restitution is necessary to be paid by Ms. Gallagher. And to clarify, I've also gone through in the paperwork with Ms. Gallagher each of those different punishment ranges from first degree, second degree, third degree, as potentially applicable to her outcome.
It also doesn't change the state's offer, regardless of the punishment range changes, but the offer in the case remains the same.
Which is
10 years deferred.
okay.
And
the plan
amount of
is it's
restitution
going
will
to
be
be disposed of in a deferred or unadjudicated fashion, and the defendant would be placed on probation for up to 10 years in length. And the problem is that if you fail on probation, it could be catastrophic, to say the least. Now, you could be looking at up to life imprisonment, depending upon what level it is the court deemed restitution is. So that will be the first step. We'll have a hearing later on, and then we will take up the matter of disposition.
Yeah, she signed
But
the document on there.
has Mr. Gertz gone over with you every level of punishment range options, which are dependent upon the amount of loss, which is still yet to be determined? We will have a subsequent hearing on that. Are you familiar with all of these levels? Do you understand fully what the ramifications are? Again, the punishment range will depend upon the restitution that the court deems appropriate after the subsequent hearing we're going to have on that. And then you would be placed on deferred or unadjudicated probation where you are not found guilty, and it would be up to 10 years in length. And needless to say, restitution will be a necessary element if you are placed on probation. And the timeliness and the amount that you pay back have a lot to do with other factors that will come into play on conditions of probation. And if you're placed on probation, there will be terms and conditions of probation, which are not only normal, most of which are normal and customary for probationers. But in your case, if there's an amount of restitution still remaining, that's going to be foremost on this court's concern, to get paid back as soon as possible, for which timeliness of doing that, putting the victim back whole, is in your best interest, plus it is rewardable, as this court has always historically done, by people paying back timely and getting that back to the victim. Because every day the victim is out, and we're talking about several $100,000. Every day they're out that money to use. It's an interest and a value that they don't have that costs them. And so they continue to be punished. So, and that's the way you fix it, is paying it back. Yes. Unlike if you break an arm, you can't unbreak it. It might heal back to some degree, but it's still broken. Here, you pay the money back. All right. So you've gone over the different punishment range. You know what the circumstances are in this case. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this indictment charging you with theft? Guilty or not guilty?
No contest.
Stand by.
You can't be easily. It says that.
No contest. Do you understand, or are you making that plea voluntarily, knowingly, intelligently, and based upon discussions with your attorney? Do you understand that a plea of no contest plus supporting evidence to that plea that the court will allow subsequent to this or today if you want, but that would be enough to find you guilty it could be enough to find you guilty if proven beyond a reasonable doubt. And it has all the same consequences as a plea of guilty, but it cannot be used in other types of courts, such as civil courts. If a lawsuit was filed, then a plea of no contest, it would take more than that for a disposition to be rendered on behalf of a plaintiff suing you, for example. But otherwise, pleas of no contest in this court end up criminally in the criminal end having essentially the same consequences. You can be found guilty beyond a reasonable doubt. Your probation, we will be putting you on, if all of this works out, the deferred or unadjudicated probation is going to be pending failure to follow the terms and conditions of probation, which are similar to all other types of probation, are required. Failing to do that could result in a motion to revoke probation being filed. Then a finding the court could make, if proven legally, where your probation has failed by conditions of probation, and you could be revoked, then found guilty at that time beyond a reasonable doubt, and then sentenced up to the full range of punishment, whatever this becomes after the pre-sentence report is prepared. But once again, going back, these terms and conditions of probation, the most important one is going to be restitution, especially under these circumstances where there's such a large amount of loss. I want the victim placed back in as whole a position as possible under these circumstances as quickly as possible. Do you understand my sense of urgency?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
And again, how do you plead? No contest, correct?
Yes.
And you're doing that voluntarily, knowingly, intelligently, and because and based upon discussions with your attorney, understanding that it can have the same consequences as a plea of guilty, except for the other reasons that we went over.
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 tendered into evidence and without objection.
We have no objection.
Admitted. Among other things, this states you are mentally competent to enter your plea of no contest. It is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are pleading no contest to it voluntarily, knowingly, intelligently. And you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God, it states. Correct?
Yeah.
State's Exhibit 1 is made a part of the record for all purposes. Is there anything we need to do today?
No.
Nothing else we're going to do today. We're going to reset this for a pre-sentence report then come back, and then we will have the other parts of this hearing that need to be addressed because there needs to be some evidence placed on the no contest to support a court's finding based upon because we're not pleading guilty. It's still, there has to be something that supports the plea of no contest so that the court can make a finding beyond a reasonable doubt.
That's correct, Your Honor. We believe that the witnesses that will call for the amount of restitution will also support that finding as well.
And what is the date?
December 18th.
Okay, December 18th.
Thursday.
How's that doing for, okay, what are we doing about return of money?
Judge,
Of some sort.
we're going to make a substantial payment.
On that day?
In advance of that day, yes, Judge.
Okay. Oh, you're doing it before that day?
We will have it done by that date, yeah.
Okay.
And then the amount of remaining restitution will be determined at the hearing.
Is there an idea in mind about how much we're talking about?
Again, Judge, it's a six-figure number.
There's only 1 million of those. Or I'm sorry, 999,999 of those.
I'm on it.
Okay, it's probably, you're saying you don't want to show your cards yet because you're still calculating.
Correct.
Thank you. I'd like to know about what that is as soon as we can. So we got a hearing coming up on the 18th?
Yes, sir.
All right, of December, and the victim at least will somehow have some recompense on or before that date to some degree that you're saying you're contending is a substantial amount.
Yeah.
Good for everybody. All right. Anything else? Then we're in recess on this case.
Thank you, Judge.
Okie dokie. We have a full picture where that one's going now. Let's go back to Florida. Brantley Clark looks like he has another parade of zebras today.
You can substitute one NA meeting per community service hour. $250 public defender and cost prosecution fee. All prior and complete conditions not herein modified or reimposed.
That's the agreement with the state.
These are previously been approved for a WARE program. So.
All right, ma'am, you can lower your hand and state your name.
Casey Nicole Lawless.
Ms. Lawless, you heard the announcement of Mr. Spitzer. Is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning, which would impair your ability to enter the agreement or understand any of the terms and conditions of it?
No, sir.
I've been handed a violation of probation community control plea form. There's a signature of the defendant line. Is that yours?
Yes, sir.
Have you had a chance to read that agreement?
Yes, sir.
Have you had a chance to go over your case with Mr. Spitzer?
Yes, sir.
Have you had sufficient time to speak with Mr. Spitzer about your case?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
You understand that by admitting you violated the terms and conditions of your probation, you're waiving your right to have an evidentiary hearing?
Yes, sir.
You're waiving your right to require the state prove the allegations against you?
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, sir.
You're waiving your right to present any defenses you may have to the allegations. You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the evidentiary hearing, which would be a decision you'd have to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Ms. Lawless, do you feel the pleas in your best interest?
Yes, sir.
You agree you violated the terms and conditions of your probation by testing positive for a controlled substance and picking up a new charge?
Yes, sir.
I'll find as a basis for Ms. Lawless' admission. I'm going to find her admission was freely and voluntarily made. After consultation with her attorney, I'm going to accept it. Her probation is modified as follows. She'll enter successfully complete the AWARE program and the aftercare. This will be a bars to bed, which means you'll remain in the Bay County Jail until a bed becomes available. The AWARE, any violation of the jailhouse rules or the warehouse rule or WARE rules can serve as a basis for an admission for an affidavit of violation of probation. The balance of your supervision will be on drug offender probation. You may substitute one NA meeting per community service work hour. All conditions that were previously imposed are reimposed. There's an additional $250 imposed today for the cost of the prosecution of the violation of probation. You have 30 days to file a notice of appeal if you wish to appeal your judgment sentence. If you'd like to have an attorney to represent you and you can't afford one,
One may be appointed to represent you at no charge. Good luck to you. You need to step over and speak to the probation officer.
All right, thank you.
Yes, ma'am.
All right, looks like they need to rack up another set of contestants. While they do that, let's go to Louisiana. Let's do that.
2025. We're at headquarters in Baton Rouge, and you can see from our name tags, we've been conducting hearings this morning, who we are. And of course, for purpose of the record, I'm Steve Frater. Chuck Tillis is to my left. Pete Freeman is to my right. You are Mr. David Peters. Is that?
Good morning, good morning. Time is 9:22, the date is.
Okay, are you Mr. David Peters?
Yes, sir.
Okay, and what is your DOC number?
552699.
Okay, and the staff there at Allen Correctional Center, would you introduce yourselves, please?
Assistant Warden Crystal Simon. Just the manual classifications.
Okay, thank you. And we'll call on y'all in just a moment at the appropriate time. Mr. Peters, your case has been assigned to Pete Freeman, who is on my right. He's going to ask you some different things and walk you through some things and get your statement and talk to the warden and assistant warden. And then we'll ask some questions and we'll make our decision. Pretty simple process. I think you're familiar with the process. Is that correct?
Sir. Yes,
Okay.
sir. Okay, I'm going and read some more information into the record. If you disagree with any of it, we'll discuss it. You're officially classified as a second felony offender. You have a parole date of 2/2/2018, a good time date of 9/5/2032, a full term date of 2/2/2033. You're serving 20 years total for habitual offender distribution of cocaine. Does that sound correct, Mr. Peters?
Yes, sir.
Okay. Mr. Peters, tell me what you did to get yourself put in there and why should we consider letting you out today?
I was using drugs and selling drugs. That what got me put in jail.
Okay, and what have you done over there that makes you think you're ready to get out today?
I've done classes. I've done Big Brother. Boys to Men, AANA, SERP, Cage of Rage, Thinking for a Change, Celebrate Recovery, Financial Peace, Cage of Rage.
Yeah, you've done a lot. I'm looking at them. I got your classes. Which one of those classes did the most for you?
I'm gonna say they got a new program on our tablet called Chase the Dragon. It's a drug rehab on our tablet, new tablet. I like that one. It teaches me a lot. It teaches me what drugs do, to me and the people that I sold it to, how I messed their family up, my family. What you should do, if you're feeling like you want to use drugs, it teaches you a lot. And I'm glad I got that. We just got our tablet like 2 weeks ago. So I think that was like a blessing or something for me to see that. And like 3 days ago, one of my fellow inmates brought it to me and told me to check it out. And I've been watching it ever since. It's called Chase the Dragon. It teaches you a lot. It really teaches you everything the other classes taught you all in one.
Okay. All right. Warden, what do you have to tell us about Mr. Peters, Ms. Simon?
Mr. Mr. Peters, has been doing all the things that, he has been in his previous boards told him to do. He has put forth some effort. I've seen that. If he has the strong support on the outside, like family and other tools, I think he would he would benefit from that, as long as he has that support.
Okay, Warden, I appreciate that, sincerity there. All right, Mr. Peters, what we're gonna do now is I'm gonna hear from your supporters, which y'all all, try to keep it to 3 minutes or less. We have a bunch of hearings today, but first we want to hear from Tamiria Chapman. Ms. Chapman? I think she's on Zoom.
Hello, you can hear me?
Yes, ma'am. Tell us what you want us to know about your brother.
My brother is a good person. Yes, he did make mistakes in his life, but he's now changed and we support him to the best of his knowledge. And I have 5 different jobs. If y'all can let him out today, with violent crimes, he will be able to work for them, and we will take him to work and be there for him and support him as much as possible. And I think he's a changed man, and I think y'all can give him a chance, if y'all can, to let him out and be with his family. The holidays are coming up, to spend time with his family. He have a niece that's about to graduate from college. He missed all their lives. And I think he will be a changed man to come home for society and do what's right and what's best for the family. And we will support him as needed. And he also have a mom. My mom is sick. She worked 2 jobs and she's tired, she's sick, and he got a house that he can come home to. We will do everything in power to keep him straight.
Okay. I thank you, ma'am. Appreciate it.
Thank you.
Janice Chapman, Mr. Peters' mother. Ms. Chapman?
Yes, sir. Yes.
I want us to know about your son.
Yes, I'm David's mother. David's a good person. He made a mistake, but I'm asking you to give him another chance. I'm like my daughter said, we sick. We have our own home. I worked 2 jobs to support him, and I'm gonna be there for him. He have a brother, and he's worked for the garbage truck, and he's gonna be there, and he got like 10 nieces and nephews, and I'm asking you to give him another chance to come out here and do the right thing. I believe if you give him another chance, I think David could change. So David is a very good person. Like I say, he just made a mistake, and I asked the Lord to give him another chance to come out here and do the right thing, because right now I'm sick and I need him. And I know one thing, the world is different out here today, and I know one thing. He done done enough time to come out here and do the right thing. And I'm praying, asking you, begging you, Lord knows, to give my child another chance to come out here and do the right thing. And I think he paid for his mistake long enough. And I asking you, I'm begging you to please give him another chance. Because right now I'm 61 years old and I'm sick.
Okay.
And I haven't had my children together in 12 or 13 years. So I'm asking you, please, to give him another chance.
Yes,
and
ma'am.
I ask the Lord to do the same thing, and I will appreciate it. Thank you.
Thank you. Miss Karen Dorsey, fiance.
Hi, my name is Karen Dorsey. I'm David's girlfriend. I've been with David on and off since we were both 15 years old. We're both now 38 years old. So besides his family, I've been doing this. Because as you know, he ran the streets, everybody knows what. So to see him go from that immature young man to the strong mature man that he is today, it really amazes me. We talk on the phone every day. Our conversations over the years have grown from him playing around, not taking life seriously, to the conversations now of him being ashamed for not being there for his sick mom. conversations of him anxious to want to get home and prove that he can provide for his family the right way. We had Bible study, we pray almost every day. We talk about his dreams. I can tell you, I've never heard him talk about a dream like that has come up over the years as of recent. So I believe that the difference in before and now is that he has a plan set in place that he is set on accomplishing. He was told to take a class, he took multiple, he was told to stay out of trouble last time he has. I have several jobs lined up, one being my job at a printing company in the warehouse. My mom knows a supervisor at the chicken factory and that's close to his home that makes good money. Frito-Lay company who is currently hiring providers, convicted felons. He has 2 side jobs so he can maintain multiple income, so he can't even have the time to think.
So y'all prepared for it.
Yes, and I would just like to say, I know it has nothing to do with me, but there's no way I would have put my life on over 15 years for someone I didn't truly believe in and think would come out, do the same thing in return. We have no kids. Again, I'm 38 years old, and I'm a firm believer that God has something to say. So pray that God touches your moral convention and you free to us today, because we greatly need him and he needs to be on speaking. Be a great asset to us in more ways.
Okay.
Besides the jobs and support, what about him going to some
My church, I attend Living Faith Christian Center. They support convicts. They have programs that where I forgot the name of the courses, but I looked all of that up and talked to my pastor about it. This class is how to become a better man. It's another class that introduces felons from going from in jail to introducing them. It's a mentorship, talking to young men on the street, going around encouraging them about his past lifestyle that will keep them out of the same situations that he's in.
Okay, thank you.
Thank you very much. Okay, Ms. Hogan, and I apologize for not letting you introduce yourself at first and telling me when you wanted to speak. But if you will, go ahead now and tell us what you want us to know about your client.
Thank you, Mr. Freeman. Good morning to all the board members. I'm very grateful to be here today. I've represented David almost as long as I've been a lawyer. I started representing David back in 2017. As the board noted, he was sentenced in, he served approximately 13 years this November for distribution of 1/10 of a gram of cocaine. And I have also, like Karen was saying to you, I've also personally witnessed a change in David. Him articulating the impact that drug dealing has had on his community and on his family is profound. And in addition to that, he's taken so many classes. In addition to the classes he took while what had happened with David was he had tried to go to the reentry program some years ago, and he didn't complete the reentry program. So they multi-billed him because he didn't complete the reentry. There was actually an issue that he'd had with a lifer at Angola that caused him to get dismissed from the program. So he just pled straight up to the charge and been sentenced, he probably would have been home, on good time, maybe 10 years ago or 5 to 7 years ago. He tried to better himself then, and he's continued to better himself throughout his incarceration. He's 33 years old. He's a completely different person than he was. He has a strong family that love him. Karen has been there for him as long as I've been on his case. And for all of these reasons, we would ask this board to grant him release. He didn't mention it today, but he does have a plan he likes going to AA meetings. And if the board wants him to continue with that, I know that Karen has faith-based and also other support, but I'm sure that they could also find a 12-step meeting for him to attend for some time whenever he gets out, just to help his transition.
Okay, Ms. Hogan, it seems like you know him very well. I've read this case. I was on his last panel. Matter of fact, yes, I was one of the votes that denied him. And he's done what I've asked since then. He's got no disciplinary problems, and he took another class. My concern is, do you think we have done enough for the drugs? Should we send him to Steve? Should I recommend? I'm not gonna say my panel will go along with me, but do you think it would help if we send him to a DOC approved facility prior to release?
I don't know that that's necessary. Just given his disciplinary record, he's taken Celebrate Recovery. He's done Living in Balance 1 and 2. He's doing other classes. He hasn't had an issue with drugs. He hasn't had any kind of contraband I think that there might have been a failed drug screen maybe 10 years ago or something like that, but he hasn't had any kind of drug write-ups recently. And he seems extremely clear-headed every time I've spoken with him and with his family. So I don't know that that is necessary. He would absolutely abide by any conditions if he's granted release to attend 12-step meetings every week and be with his family. But I think that David has articulated, he lost 13 years of his life for selling drugs and for using drugs. And he would not take lightly the chance to go to rejoin society. So I think that if this board does grant him release, he's not going to slip backwards, and anything that he needs to do, whether it's random drug screens or going to AA meetings, he's more than willing to do that. But I don't know that Steve Hoyle would be necessary. That's just my opinion, Mr. Freeman.
Okay, well, I asked for your opinion. Thank you.
Thank you.
Okay, all right, I'm gonna just note some things, Mr. Peters. First off, I do want to state that the opposition you have was blanket opposition. The judge and the DA had no comment. You know, and you've had a very violent past and a history that's what caused my concern last time. You sound real good today. And you've been in there how long? 13 of 20 years?
Yes, sir. 13 and a half years.
Okay. And you had the one incident where you lost a good time, but we talked about that last time. I have no further questions. I'll be ready to vote when it's time, Mr. Chairman.
Okay.
I have no more questions.
I don't have any questions.
Okay, you know, I wrote down, go with the interview and what the warden says. So, because that's where I was stuck. It looks like you think you can make it on the outside with any further help from any kind of treatment? Or do you think you need that treatment? You tell me, do you think you need that treatment?
Yes, sir. 8 classes, I attend them.
Oh, no, I know that. I was just talking about the inpatient. Okay. All right. My vote today is going to be to grant your parole with the special conditions that you take monthly drug screens for the first 6 months.
Yes, sir.
Be random. That you go to at least 2 AA meetings a week for the first year. And then after that, if the officer thinks you don't need them anymore, then they can write to us and we'll dismiss that condition. And also, I'm not gonna put you on electronic monitoring, but I want a curfew from 9 to 6 unless you're going to work or to court. Okay, you don't need to be running the streets.
Yes, sir.
All right, that's my vote.
Thank you.
Mr. Tillis?
Mr. Peters, I voted for you last time, and I concur with Mr. Freeman. I'd like to see you stay with AA and random drug tests. So I concur with Mr. Peters.
Okay, and likewise, I'll concur also. I think that you can make it on the outside. You got good support. Please don't disappoint us. Don't disappoint yourself, and don't disappoint your sister and your fiance, you know, because a lot of people going to bat for you. Anyway, that'll conclude this hearing. It's 9:40 in the morning and end of the hearing.
Thank you.
Thank y'all.
Approved? That is a rare thing here at TCF to see a unanimous approval from the board in Louisiana. So good for him. Hopefully he does well. I don't know if you noticed the family member there got up and started cheering. So yeah, hopefully it all works out. Let's go back to Michigan, spend a little more time with Judge Simpson.
Your Honor, regarding the pretrial, I I suppose I asked for an adjournment. We're still in negotiations. And then there's a bond issue we should address as well.
Yeah.
So Mr. Adkins had some missed tests and saw a positive test for alcohol. Regarding the missed tests, we have been in touch with the place that he's been testing at in Flint. It seems like there's a little bit of delay in getting those results here. For example, that there was a test on the 31st that when we were here on the 5th was said it was missed. He did test on the 31st. That result is now on that report that was sent by Community Corrections. So we're trying to work out
the alcohol.
Yes. So we're trying to work out the kinks on the delay on getting the test to Community Corrections. So that's the first piece. The second piece is the positive alcohol test. I've had multiple conversations with Mr. Adkins regarding the positive alcohol. I think today he would like to admit to the violation with a bit of an explanation. He is, I think Mr. Adkins' road to sobriety is a pretty long and interesting one. He was addicted to opiates. As of last year, he relapsed, but before that, he was clean for about 3 years. He was completed inpatient treatment. He was working as a counselor at a sober living house here in Ann Arbor. He was a sponsor. He had worked through the steps multiple times. So he's very familiar with substance abuse addiction and the struggles and journey that can take a person on. He obviously admits that they relapsed last year. Again, he struggles with opiates, and he's been clean from opiates now for over a year. Is getting back into that sobriety journey. He is going to AA weekly, and has moved from Ann Arbor, where his primary, problem was, to Flint, so he can. He's living with his brother, who's also 9 or 8 years sober, and re-enter that sober living lifestyle. So Mr. Adkins again admits to the violation. At the last court date, the court ordered him to come here to test in person. He did. The court ordered also for him to come in person today. He explained to me that his mom drove from Saginaw to Flint to pick him up and drop him off here. He's not trying to run from anything. He wants to take accountability for his actions. And I think he's doing that by admitting and trying to work through all of this. So I don't know if you want to say anything in addition to that, Mr. Adkins.
Your Honor, I take full responsibility of the positive alcohol test. I go to NA and AA meetings weekly in Flint. And I just want to not lose my job from incarceration, so I can continue to, pay for what I need to pay for, and so on and so forth.
He's willing to step up.
But has he taken the test? I mean, I got missed test and unable.
So
I don't have him testing.
There was an unable, I can't remember the dates off the top of my head.
November 12th.
Last week, he said he did go in the 13th and test to make up for that 12th. He did show me a PDF of those results, which were negative. It says on them that the sample was taken the 13th and it was received by the testing facility. The results were received by the testing facility on the 17th. And so he did test on that date. He did test on the 17th.
You're saying he did?
He did. I think here in community, maybe the difference is here, the results are done immediately at Community Corrections, from my understanding. It seems like at this testing location in Flint, they are sending the tests out. And that's how we get the sample taken on the 13th and the result coming in on the 17th. And that's delaying those results getting to Community Corrections, which is delaying the results getting to us. So I think that's part of the issue of the delayed or the missed tests that are reflected on our reports. But then, like I said, there was one that said he was missed on the 31st, and now we'd have a result for that test. So it shows that he did test, although it is a positive test.
Shelters.
Your Honor, based on the report, I trust defense counsel representations, of course, but based on the report that's before me that I'm looking at, in 1 month, we've had one compliant test, which was November the 7th, which was a test that the defendant had 2 days of notice for. The court recalls on November the 5th, when we were here, the court ordered him to test by Friday. So he had 2 days to go to that test. I believe the science and what we're seeing here is a pattern of alcohol use and refusals or missed tests. If the court recalls at the time of arraignment, I let the court know that this was an OWI second offense. The prior is from 2019, which is not that long ago. And the defendant was found passed out behind the wheel of his vehicle, had to have 2 doses of Narcan to even come around at all, and was discovered to have 47 nanograms of cocaine in his blood. I'm extremely concerned for public safety. I think it's great that he's moved in with his brother, but clearly that's not working because he's been residing there since the pendency of this case, if I recall correctly. And we're having these tests that are showing ETG. We had 1 for THC, and we're seeing non-compliance. The concern of the people at this time is public safety. And I'd ask the court at this moment, remand him for the bond violation. If the court is inclined to release them, I would request a scram tether, as well as the continued intensive supervision for drugs. That's also an issue here.
Anything else?
Anything else from you?
No, ma'am. So here's part of the problem as I'm seeing it. And yes, I'm concerned about public safety, but I'm also concerned about this defendant. The thing is, you know what it takes to get yourself sober. And I'll just put it in a colloquial sense that what you're doing right now is you're just half stepping. And you know that. You know that you are not doing what it takes to get yourself there. And that's why things are coming out and working this way for you. You got to make up your mind, young man. If you want to do it, you know how to do it. You've done it. You just have to do it. This half process for you is not going to work. And you got to figure that out. But if you think that what I'm going to do while you're in the process of trying to figure that out is allow you to be out there, be in a position where you decide to get behind the wheel because you're doing whatever and then end up killing somebody, that's not going to happen. So what I'm going to do is I'm going to adjourn this to December 3rd, 2025, 9 a.m. He figure out in that time what he wants to do. But at this time, his bond is revoked, defendant remanded. Court does call the case of the people versus Murtada Al Khalaf.
People. Good morning, Assistant Public Defender on behalf of Mr. Al Khalaf. If you're sir, state your name for the record.
Thank you.
Your Honor, the last hearing, Mr. Al Khalaf was working on going to Secretary of State and getting his license. I'm not sure if Mr. Al Khalaf has an update on that. If I request an adjournment.
Did you get your license, young man?
Not yet.
Why?
I went and had a talk with the lady I did back like 2 months ago, and she's just, still looking at some stuff to see why, and I'm still waiting for her to give me a response back.
You need to go down there and figure it out. I'll adjourn this out to December 17th, 2025, 9 a.m. I want to see some progress on this. Otherwise, we'll have to deal with it a different way.
Will do.
All right. Thank you. Continue.
Thank you, Art.
Court calls case People versus Marcus Jackson. It's an arraignment. Your name, sir?
Marcus Jackson.
All right. Sir, you are before the court on a new complaint that alleges that on or about August 17, 2025 at the location of 2376 Carpenter Road, that being the Quality and Parking Lot, that you did operate a motor vehicle while intoxicated. You understand the nature of that charge, sir?
Yes, sir.
That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Court could also order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the costs of the prosecution, as well as the cost of any emergency governmental services. You understand that, sir?
Yes, sir.
All right. First question I have for you is, do you wish to be represented by an attorney on this matter?
Yes, sir.
This is a public defender case.
Assistant Public Defender Natalie Pate, with and on behalf of Mr. Jackson, we would waive any further formal reading of the complaint. My client stands mute, and I would ask for an adjourned pretrial date, please.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. I will adjourn this matter to December 3rd, 2025, 9 a.m. As to bond in this case, alleged BAC.
.126, Your Honor, the defendant was found passed out in his car with the vehicle running in that parking lot. And Your Honor, from what I can tell, there may have been a prior offense from the state of Georgia, but I'm not able to confirm that at this time.
Okay. Is this the only thing he's held on? Or
Your Honor, Mr. Jackson indicates to me that he has other matters that are holding him right now, so I would ask for a nominal bond the court would allow.
That's correct, Your Honor. I see an open plea third, as well as potentially another OWI.
Got it. Set his bond at $2,500, 10% bond. Although the standard conditions, including no assault behavior or possession of any weapons. There's to be no use of any alcohol, recreational marijuana, or any illegal drug. I will order that if the defendant is released, he is to report to the Department of Community Corrections placement on a SoberLink testing device. I'm also going to order drug testing at 2 times per week.
Next date was December 3rd.
Yes, ma'am.
Thank you so much.
All right. Thank you.
Thank you, Your Honor.
When did he get here? There's nobody behind you. You know who I'm looking at. When did you get here?
With me?
And stop. Don't bother Miss Valtez. He's busy. So move your chair away. All right. Good. Court calls the case. People versus Divine Julia Martinez.
Conrad Solar on behalf of Pittsfield Township.
And Assistant Public Defender Natalie, on behalf of Ms. Martinez, I have been informed that she is at Washington County Jail, but I've been informed she doesn't, is not coming up.
She doesn't. She's refusing to.
I think that's the third time. That's the third time.
1, 2, 3. This is the fourth.
4. I missed one.
Yeah.
If I may just say for the record, she is being held on some other matters, and Ms. Cannon from our office has been working with jail service
working with jail services regarding her mental health treatment and then possible release to treatment. But she is being held on other matters at this time, but there are pieces to things. So I would ask for, we were to be requesting an adjournment anyway.
December 17th, 2025, 9 a.m.
Your Honor.
Court does call the case of the people versus Zion Jones.
Conrad Solar on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Jones. Mr. Jones, state your name for the record.
Zion Jones. All right, what are we doing?
We're requesting an adjournment. Mr. Jones would like to see if he can get his license. He is being held on a $25,000 bond. I think it's up before you tomorrow. Do you have court tomorrow? So I guess we'd like to see how that shakes out if he gets out of custody.
December 3rd, 2025, 9 a.m.
Thank you.
Bond continuing investment. Thank you. Court does call the case of the people versus Hassan Isa.
Ashley Feltus for the people.
Oh, why'd you put his case up?
Well, it was scheduled for 9.
No, Mr. Isa's fine. It's you. That's the problem.
Always a pleasure seeing you, Judge. Your Honor.
State your appearances?
Yes, Hugo J. Mack, Your Honor. P300997 for the record, with Mr. Isa. Your Honor, I have been in touch with the prosecuting attorney's office, but I have not had a chance to speak to the prosecutor. We may well be able to resolve this matter today.
Mr. Mack sent me some documentation related to his client's status at the time related to his vehicles that I want to go through with the trooper and give a little bit better understanding about what happened. So I'm requesting a little bit of time to do that.
Okay. So it doesn't look like it can be resolved today, but you've gotten the information to her, correct?
That's correct.
All right.
Yes. So, Your Honor, I'm not sure what the next available date is. If it's December the 3rd.
That's my next available date.
That's okay. I've got like 7 matters in front of your colleague on 14A2. So it would.
For Judge Barr?
Yeah. So
does he want to see you?
We could do it. I don't know. It's.
I'm just asking.
Judge,
I'm just asking.
Jury's still out on that one.
Okay. All right. I'm just checking.
So we could do it. That
Are they in the morning or what?
Is scheduled for 9 o'clock. So, and I anticipate those matters going real quick, Judge. So could we get 10 o'clock?
Yeah, you always anticipate things going quick and you start.
Can we get 10 o'clock on that day? Is that possible for you?
So every time he comes up here, he wants to pick his block. And what do I tell them? No, that's not how it works.
Oh, okay.
I tell you that all the time, Mr. Mack. Here's what I'm going to do.
Yes, sir.
I'm going to set it for December 3rd, 9 a.m.
Okay.
Now, when we divide it into blocks, we will see where we can put you.
You know, Judge, that's why I carry your pitch with me at all times.
Bond will continue. All right. If you've got a scheduling issue, Ms. Weidling will be more than happy to try to accommodate. Can't guarantee it, won't guarantee it.
Okay.
But if you let her know by email, okay, do not call her because I told her don't talk to you.
Okay.
All right.
A long list of knowing fans, I might add. Okay.
All right.
Okay. Thank you.
That's the way. Thank you, Mr.
Okay.
Here.
I'll let you know.
Court calls the case, people versus Jeffrey Ostermiller.
Ashley Feltus for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Ostermiller.
He is here. Sir, state your name.
Jeffrey Ostermiller.
Your Honor, we are requesting an adjournment. Mr. Ostermiller has a case in the 15th district court that is going to tomorrow that we'd like to see what happens on first.
Got it. I'll adjourn this then to December 3rd, 2025, 9 a.m. or as your invite indicates. Okay, thank you, Mr. Ostermiller. Bond continued.
Thank you, Your Honor.
Court calls the case, People versus Shondell Barrett.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Barrett. Ms. Barrett, state your name for the record, please.
Shondell Barrett.
Thank you.
You're welcome.
I believe we're close to a resolution. I know Ms. Barrett wanted to just cross some T's, dot I's.
Yeah.
But so I'm asking for an adjournment just so we can make
No,
sure.
I actually texted you yesterday and told you it was okay to just go ahead and do what we were initially talking about doing.
Okay.
Yeah.
So we do have a resolution then. I just need to have you sign some paperwork, Ms. Barrett.
Okay.
So we'll.
December 3rd, 2025, 9 a.m.
Oh,
Okay.
No. I
What do you
was
mean,
just
no?
signing papers. I mean, no. I'm just saying I thought we were signing papers. Like, we still have to come back, or is it something different that's happening? I'm confused now.
Okay, no, I adjourned it out to December 3rd. And that way, that's going to give you and your attorney time to go through the paperwork that you need to sign to get the agreement all set.
Okay.
Okay?
Mm-hmm.
Bond will continue. Thank you. Court calls the case, People versus Thomas Bittner.
Okay. What is going on now?
Hold on a second. Like, slink in. All right.
I actually felt the same people in the vendor matter.
This is the public defender Lauren Perry on behalf of Mr. Bittner. Your Honor, we have come to a resolution.
Is he here?
He's not, but he has given me permission to admit to the civil infraction with no proof of insurance on his behalf.
Got it.
And I would add that as account 257328, Your Honor.
And Ms. Perrine, on behalf of your client, do you bear responsibility to the fact that on September 24th, 2025, at the location of Michigan Avenue in Pittsfield Township, Washington County, State of Michigan, that upon the lawful request of an officer, defendant was unable to show proof of insurance?
I did.
Court will accept that admission to that charge. Fines and costs of $155. When can he pay that?
He's asking for 2 weeks.
2 weeks. They pay it by December 12th, 2025. Thank you. Court does call the case of the People versus Candace Brooks.
Spell this for people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Brooks. Your Honor, I'm not sure if Ms. Brooks is here. She was adjourned to the state, but then was not on the docket that was sent out. I did not. I think there was I don't know if it was a clerk's. I frankly, I did.
She was not on her docket, you're saying?
She.
I adjourned it out today.
That's correct. I did not contact her about today is what I'm trying to say. So I don't know if she.
December 3rd, 2025, 9 a.m.
Thank you.
Otherwise, we were going to be here till tomorrow with your explanation. Court calls the case, People versus Leslie Brown.
That's spell this for the people.
Good morning, Public Defender Lauren Perry on behalf of Mr. Brown, excuse me.
Sir, can you state your name?
Leslie Brown.
Thank you.
There has been an offer extended. Mr. Brown just wants a little bit more time to consider that offer.
Turn it to December 3rd, 2025, 9 a.m. All right. Bond will continue. Thank you, Mr. Brown.
Thank you.
All right, getting towards the end of the day, let's go back to Louisiana and we'll end on one more of those hearings.
In the morning, it's the 19th day of November 2025. The board here, as you can see, is Mr. Tillis to my left, Mr. Freeman to my right, and I'm Steve Prater. We'll be handling the revocation hearing for Mr. Henry Clifton, who is at East Baton Rouge Parish Facility. Is there any staff from East Baton Rouge in the room?
Yes, sir. Lieutenant Murphy.
Lieutenant, thank you for hosting us today. We appreciate that very much.
You're
Mr.
welcome.
Clifton, would you tell us, you are Mr. Clifton, correct?
Yes, sir.
Okay, Mr. Clifton, what's the purpose of the mask?
The mask is for tuberculosis, whatever they got going on here. I'm just trying to keep myself from getting sick.
Okay, okay. Would you is that okay if you take it down for now so we can hear you and see your lips moving?
Yes, sir.
Okay, thank you, sir. Okay, your case, well, let's see, what's your DOC number, sir?
531107.
Okay, and have you signed a waiver form of the hearing, agreeing to this hearing today and understanding that if you're gonna have a lawyer that it'd be a privately funded lawyer?
That's that paper in front of you. Yes, sir.
Okay, did you sign that paper?
Yes, sir.
Okay, all right, Mr. Tillis to my left is gonna be handling the questioning and calling on your supporters to speak. So, Mr. Tillis, would you take it away?
Good. Good morning, Mr. Henry. How are you?
I'm fairly well, sir. Thank you. Good morning.
I'm going to read some violations and you can plead guilty, not guilty, or with a statement. Rule violation 4. The offender failed to refrain from criminal activities due to an arrest for simple battery on 4/10/2025. The subject was served with protective order on 7/29/2025 and was found to be in violation of the order, failing to leave the residence location 5568 Lancaster Avenue. Hearing continued 10/21/2025. Trial same date on 10/21/2025. The pending charges of simple battery was dismissed in city court. How do you plead? Guilty, not deal with the statement.
I don't know how to plead with that. I don't understand because this is my first time being in front of the parole board. Now, I guess maybe I should plead with a statement. I suppose my statement would be that the only defense I have is that my charge was dropped. Yes, sir. And that it did not happen in accordance to how it was stated. I do not wish to waste the board's time, sir. I'm just trying to get a good understanding of how this even works. I'm not sure. I've been doing what I could to stay out of trouble.
Okay, you were arrested for simple battery. Did
I commit the simple battery? No, sir.
Okay. Tell us what happened.
Okay. So, my brother I live with, and I was in bed that morning. He was going to work, and his daughter was taking him to work, and I believe this day was her birthday. And so she took him to work and come back to the house and turned the radio on in the living room and had it vibrating the walls. And I don't know if she cared or not, knew or not, or what have you, that there was someone in the house. I believe she knew that I was in the house asleep. And so I made it known that I was in there asleep. I got up and I made my presence known, and I beckoned for the radio to be turned down. She didn't do it. And I went on and went in the living room and unplugged the stereo. She couldn't get up. She couldn't do it because she was dancing on the floor. She didn't even see me when I was beckoning for her to turn it down because she was dancing on the floor. So I walked past her and unplugged stereo. She got up off the floor and proceeded to stop me from unplugging it. And I left it alone and went back to the bedroom. She called the police. I called my brother. And he came. While they were there, they wrote me a summons. She told them that I put my hands on her. He knew that wasn't true. He pulled up from his job, drove there and talked to the police, and the police released me to him. They just wrote me a summons. And I got in the car with him and we left, and he went back to work and I went with him.
Thank you. Thank you very much. We have rule violation number 5 on 7/29/2025, while the agents were waiting for the subject to vacate the property located at 5568 Lancaster Avenue, and the subject's belongings was a machete. How do you plead?
That's not my machete. It was a shop. It was a tool shop. It's my brother's shop. I was inside my brother's shop. I wasn't in the house. I was in his shop working, doing what I was legally, what he told me I could do, what the court said that I could do. We had just went to court and got that understood that day. My witness is right here with us. My brother Orlando is on the meeting, and he has a copy of the order that the judge put in place.
Okay, we'll ask him in a few minutes.
Yes, sir.
Rule number 10, the subject failed to pay in supervisional fee and is currently $994 in the rear. How do you plead?
Plead guilty to that.
Okay. We're going to let some people speak on your behalf, which is your brother who is on Zoom. Mr. Henry, what can you tell us about your brother?
Good afternoon, Paul Borough Board. Thank you for allowing me to speak on my brother's behalf. Yes, I invited my brother to stay with me upon his release in December of 23. And he was invited to stay. I want to help him and continue to want to help him get back on his feet. I even had him doing some odds and ends jobs with me with the various things that I do. I set up sound for local bands in my hometown, and that means moving equipment, speakers, mixer, microphone, cables, and that sort of thing. So he comes with me to do those various things. I even have friends who also hire him just as a basic labor hand, helping them out in their endeavors. And he's been with me at my home ever since. The problem, the only issue was with him and my daughter. My daughter was not interested in having him at our home, and I did my best to quell her concerns about my brother. He was really just being there, just trying to do his time, his parole time, and work it down. But my daughter just simply did not want him there. And I tried to be the mediator between the two. Not that my brother was causing any kind of issue. Like I said, and this is my daughter I'm talking about. I never want to go against her, but really, honestly, she did not want him there. And we were in the process of trying to find housing just so I could get some separation between the two of them. And, we were really close to that prior to him being picked up. But no, he was allowed to work in my shop. He likes electronics. He works on those, on different things. So I have all kinds of tools in my shop. And the machete happened to be one of the things that was found. Had I known that was not something that was supposed to be even around him, I would have immediately removed it. I had no idea about that kind of thing, but I've got all kinds of tools in my shop, and having access to that was one of them. So I'm sorry that he got that charge for that, but no, there was no purpose for him being charged with that, in my opinion. He's been doing his best to just stay out of jail. I believe it's time not right now, but when he got out in 23, I believed him then. He didn't want to go back. And all I'm trying to do is help him meet his criteria, try to help him find work to pay his bills and become self-sustaining again.
Okay, thank you so much for your comment.
Thank you.
We have Miss Crystal.
Yes, sir.
You go to the podium, please. Tell us what you want us to know.
More so up here, thanks for having me, but more so of a character witness for Cliff. We met, I guess, shortly after he got out in December. And he's a good guy. He had a lot of opportunity when he was out there. He did work with his brother. That's how he worked with his brother. In my sound engineering. He had a lot of opportunity because he worked on several different projects with me, through other friends. I just know they had a lot of issues. The niece had a lot of issues with him being there, her personal issues, But I witnessed several things, her slamming the door and things like that. So I didn't see him do anything to her. So for the most part, I feel like it's kind of just very issues.
Okay, thank you so much for your comment. Anyone else have any questions?
And I'm listening to you, but it looks like you've had problems in the past with that temper a little bit, with that restraining order with your ex-wife and the kids, and then you go down there and I think you took a car, and then probation officer had to order you to bring it back because she had a protective order against you. What's going on with that? I mean, and she said she didn't like the way you disciplined the children. How you discipline?
Well, I didn't physically discipline them, but I definitely made sure that I was stern with my children and let them know that they are beautiful and that they are children that needed to have restraint about themselves, because they were in a situation in that I'm not able to be there. So I needed them to have control of themselves and not put themselves in a position to where they would be in jeopardy.
Gotcha. I have no further questions.
I don't have any questions either. I think it's time.
Mr. Henry, I agree kids should have some discipline, and you didn't physically whip them. My vote today is going to be do not revoke.
My vote's going to be do not revoke, but I don't want him having no more contact with that niece. And I'm ordering you to stay away from that niece. So if you got to live with that resident, you need to find another one, because this is going to keep happening.
So as we have my brother on the line right now, that is the only residence that I have at the moment.
I'm not letting
are-
back around that piece.
I'm actually saying that she doesn't live there.
Okay, she's moved out?
Yes, sir.
Okay.
And your brother also said he's trying to find a residence for you.
Right, well, when she comes to that house, you leave,
Yes, sir.
okay? All right, well, my vote's to do not revoke, but if
Okay,
you see
yeah.
that niece, you are to leave.
Okay, you have 2 votes to do not revoke, and you need 2 votes to carry the day on a hearing like this. My vote would be to revoke you. I think there's too much smoke here. And I think that immediately when you knew there was a protective order for you, you should have left that residence instead of sitting there on your computer waiting on the agents to get there to talk to you. Order of the court doesn't say you gotta not be around this residence until you've talked to your brother. It says don't be around that residence.
Actually,
And so I don't need you to say anything. My vote is to revoke, but I have a single vote. I got 2 that say do not revoke. So, as of today at 10:14, your parole has not been revoked. That's the end of this hearing.
Approved?
Not exactly what I thought would happen there, but, you know. I don't know. This board, we've talked about them so many times. They're surprising from time to time. Wahoo, see in the chat that you're surprised as well. You know, we had a unanimous approval of parole earlier today, which we don't often see either. So, cool, I guess. I hope y'all had fun today. I did. Things actually worked today. That was nice. It wasn't the struggle bus just trying to keep the stream going, unlike yesterday with all the Cloudflare issues. So that was good. We'll be back tomorrow, the normal time, 10 a.m. Eastern, 7 a.m. Pacific, 45 minutes early for channel members. If you're not a channel member, consider becoming one. If you're not signed up for our Discord, definitely do that, because that is just free, and you are able to get alerts every time we post and go live, because we cannot rely on YouTube to do that for us anymore. And there is a link to the Discord in the pinned chat, so check that on your way out. So yeah, go have yourselves a good Wednesday. It looks like it's going to rain here soon, which is good. The more rain we get in the desert, the better. So we're looking forward to that. And I'll see you tomorrow. In the meantime, take care. God bless.